May I please, Your Lordship? My Lord, I get to mention 5 NEC appeals. My Lord, in those cases, Lordship, award was less than 1 lakh. As per section 173(2), the appeal is not maintainable. So, Lordship, some order has already been passed by this honorable court, Lordship. I am praying for listing on Friday or Monday. Lord.
Okay.
5 cases. Similar order will require it. Yes. God bless.
Please, Your Lordship, my lord, orders matter, it may be listed next week, my lord.
May I please, Your Lordship, my lord, I beg to mention, my lord, item number 14, my lord, part third matter, my lord. With due consent of the appellant, my lord, I have taken the consent of the appellant, my lord.
Is it part third matter?
Yes, my lord. Any date on 12 or 14th August, my lord.
Is the plea portable learned addition of fee with consent the other side as well as the matter on after 1 week?
Yes, my lord.
After 1 week.
May it please, Your Lord. This to MSC appeal, my lord, was directed to be listed in the month of June, my lord, not listed, my lord. Can be listed next week, my lord. Much obliged.
My Lordship, I beg to mention for listing one IA, my lord, this court has directed the appellant company to deposit 50%, which Lordship may recall, my lord, the other day before vacation, my lord, they acknowledge that they are going to be paid within 1 week, but not paid, my lord. That matter, my lord, may be listed next week. And another made appeal, my lord, that may be for hearing, my lord.
May I please, my lord. I beg to mention item number 15, my lord. Item number 15, my lord. 15, my lord.
Yes.
My lord, I pray that this matter will be taken up after 2 weeks, my lord. I have taken the consent from other side.
The Gupta learned counsel for the appellant with consent to the other side as well as after 2 weeks. Fair law.
Obliged, my lord. My lord, I have another prayer, my lord. I pray for listing of 2 MSC appeals, my lord, in the next week, my lord, any date, my lord. 13. Obliged.
Lordship, I beg to mention for listing of one RSA for orders, Your Lordship, tomorrow day after tomorrow. One.
Please, Lordship, I pray for listing and part third matter, Lordship.
What matter?
Civil division 55. This matter was last listed on 17/7/25. But due to non-available of this court, this matter was not. The matter may be taken this week, any date, Lordship.
Not this. I'll speak about take it that. Yes.
Lordship, the concern of the opposite side, I beg to mention item number 26. Can it come Friday, Lordship?
Item
Yes,
number
26, Lordship, on the supplementary list. I'm on behalf of B. Sharma, Senate Council.
Your name, please.
D. Das.
D. Das.
Yes, Lordship.
Learned counsel appearing on behalf of Mr. P. Sir, learned counsel for the appellant with consent of the other side as well as listing the matter after
It may come on Friday, Lordship.
next Friday. Is hearing matter Friday not hearing?
Lordship, any Tuesday or Thursday, I'm appearing for the respondent in this matter. Much obliged, man.
No joke.
Yeah, please, Lordship. So, like to mention in item number 8, Lordship, we filed an additional affidavit. It may be called for, Lordship.
Okay, for it.
Obliged.
May it please, Your Lordship. I beg to mention item number 16 with the consent of the other side, Your Lordship. Matter may be adjourned for today, Your Lordship.
Miss, your good name.
M. Zomanpuri. I'll write down my name, Your Lordship. I'm appearing on behalf of the appellant.
Appearing on behalf of.
Appellants.
Appearing on behalf of.
BD Kovar, Senior Advocate.
BD Kovar, senior counsel for the appellant. You inform the other side.
Lordship, have taken the consent.
You have.
Yes, Your Lordship.
With consent of the other side, for listing the matter. When?
Lordship, if possible, on 6th of August.
Is the hearing matter? Okay. September.
4th September.
Yes.
May it please, Your Lordship, I beg for listing the matter one IA, Lordship. IS for delay condonation, Lordship. Kindly matter may be list on next week, Lordship. Any date for listing,
Take
Lordship.
it from me.
Obliged.
Lordship, I beg to mention for listing on IA. It was last posted on May of last year.
I in which column?
Orders. Obliged.
Take it from. Yes.
Include the Lordship, with the consent, I beg to mention item number 27 of supplementary, my lord. My lord. My senior is now out of station, his medical treatment, my lord. So,
You
matter
are
may be-
appearing on behalf of?
NA's mother, my lord.
Okay. You inform the other side?
Yes,
Yes,
Lordship, I am for respondent number 1, Lordship.
Okay. Mr.
R.I. Bhuya.
R.I. Boya, learned counsel appearing on behalf of Mr. N.H. Mother Boya. Learned counsel for the
After
appellant.
4 weeks, my lord.
The other side, press for this the matter after
4 weeks, my lord.
4 weeks.
Yes, my
Here alone. Yes.
May please, Your Lordship. I paid for listing CRP on Thursday. Also. In this case, Your Lordship has notice was issued and record was called for. Record also received the trial court report and notice also served under appeal. And in the meantime, Your Lordship, no stay granted. And in the meantime, execution case is filed and it also issued. I paid for on Thursday, Your Lordship. Obliged.
Maybe, Lordship, I am praying for listing one CRP item on Friday. Faster. Obliged.
My lord, I beg to mention a regular first appeal, my lord, for listing, my lord.
When?
Friday, if possible, my lord. Then, my lord, another regular second appeal is also there, my lord. On the last Friday, my lordship has condemned a delay. So, my lord, I beg to mention for this listing, because already execution is going on, my lord. Lord, 8 is fixed for execution on the trial court, my lord. On Friday, if possible, my lord, this second appeal, my lord.
It's Friday or not?
Then Monday, my lord.
May I please, Lordship, with the consent of the other side, Lordship, I beg to mention item number 17, Lordship, for a passover for a day, Lord.
1-7.
17, Lordship.
Lordship, date may be fixed, Lordship. Date may be fixed, Lordship.
Date.
I'm the respondent.
Yes, actually, quite ordered that both the parties based on this matter on.
Obliged, Lordship.
May it please, Lordship. I beg to mention two MSc appeals, my lord, for listing under the orders column, my lord. One appeal was last listed in 2023 on August, my lord. If my lord can give us any date on the next week, if convenient to this court. my
Take
lord.
it. Yes.
Yeah, please, Your Lordship. With the consent of the other side, I beg to mention item number 19 and 21, Lordship.
19 and 21.
Yes, Lordship. Kindly the matter may be passed over for the day.
My lord,
I
Your
also
Lordship,
other-
I am appearing for a respondent, in 21, I am appearing for the respondent. Can, a fixed date may be,
Pardon?
what? Yes, Lordship.
He's
Uh,
appearing for item number 21.
21, for the respondents.
Okay.
A fixed date may be given, short.
Ms. Hazarika learned counsel for the petitioner with consent from the other side. That is that the matter may be stands on the matter may be adjourned for the day. There is accordingly allowed. The matter is stands adjourned for the day. In item number 19, item number 20. Ms. Sogari learned counsel with consent from the other side as for listing the matter. When do you want?
5th of August.
5th of August.
Yes. It is quite, I mean, urgent cause the petitioner is, because the applicant, because the petitioner is having the interim order.
may I please, Your Lordship.
Your Lordship, there is interim in both the matters.
My lord, in item number,
Order was ordered.
my lord, in item number 19, I am the respondent, my lord. This matter also, my lord, in land grabbing matter, my lord, they have grabbed our land, my lord. And by taking the interim order, my lord, they are enjoying the land, my lord. So, my lord, a date may be fixed, my lord, in the month of August, my lord. 1998. In the month of August, my lord, may I kindly, my lord, in earlier occasions, my lord, they have also taken time, my lord. In the August, my lord, any date may be given, my lord.
No, Mr. Kade, your matter may not reach in the month of August.
In earlier occasions
Already a
also,
lot of matters have been fixed.
my lord, earlier occasions also, my lord, they have taken in the last part of the August, my lord. Obliged.
Bless.
Yeah.
May it please your lordship. Lordship, I beg to mention for listing one MFA in hearing column. Lordship, it's a old pending matter in the year of 2017. Lordship. Okay, obliged. Your lordship.
May I please your lordship? Lordship, I beg to mention one MSc appeal and one IA listing for orders on 12th August.
12 August. Okay.
Absolutely, lordship. My lord, MSc appeal list, my lord, last listed, my lord, in the month of February, lordship. It is not listing, lord. May I pay for my lord the next week, preferably on 5th of August, lordship. Orders. Lord, all right.
My please, lordship. Lordship, party has already settled their dispute mutually outside of the court. My instruction, lordship, to withdraw the case unconditionally.
Mr. R. Ali, learned counsel for the appellant submits that the parties have already settled the dispute outside the court. And as such, he has the instruction to withdraw the same. Here is accordingly allowed. This matter stands disposed of on withdrawal.
I left it.
Items for according to mediation, item number 1 and 2.
Yes, is there any chance for?
Yes, Lordship, the appeal is, item number 2, we have filed this appeal purely on the ground of quantum, Lordship. So it can be sent to mediation.
Lordship, actually, unofficially, we have tried for with future insurance company, Lordship. They have taken so much time, but thereafter they have not said anything. So meditation, I don't think it will give any fruitful results.
Okay. Part is there. Your good name?
AD Chaudhary, Lordship.
Learned counsel for the appellant and so you are the appellant.
I am the appellant in the item number 1.
And Ms. Vidya for
Respondent number 3.
respondent number 3. So the matter is listed under the column for reference to the special mediation right mediation for the nation. Yet it is submitted in the bar that earlier attempts are made to settle the dispute amicably, but the same failed to deal eliminated and as such, there is no chance for reconciliation and it is contended to be submitted for hearing. Accordingly, it is provided that recessal is the method for hearing the month of
Obliged, Lordship.
Obliged, Lordship.
Item 3.
Let lordship kindly see the order of this honorable court 15/7/25, my lord. It was fixed for hearing how this matter has been listed before this court on mediation matter. Because last date it was listed for referral to the mediation. And I pray that since the matter, the claim was rejected by the tribunal, and against it I have filed a appeal. And since matter has to be decided by this honorable court itself, mediation will not be the fix.
Okay.
So short date, my lord, since the matter is 2018, my lord. In the August, my lord, otherwise, in the August lordship.
Learned counsel for the appellant and Ms. Vidya, learned counsel for the respondent number 2.
7th August.
Mr. Secretary, learned counsel for the appellant submits that this appeal is deferred for rejection of the claim by the tribunal. And as such, there is no chance for reconciliation, and he submits that the matter may be listed for hearing
On
a fixed date.
7th of August, lordship.
Accordingly, it is provided that this is the matter on.
এই 18 September দূৰত হয় এটা বন্ধ হবচোন সেপ্টেম্বৰৰ পিছত no short date is required আপনি আৰু
Sir,
is a matter of 18
No, temporary.
Lordship.
Already lot of cases have fixed. On
I
temporary
understand, my
or
lord.
temporary.
Even I will try my best, my lord. If not, otherwise,
Not risk.
or otherwise not 7, my lord, can it be, my lord, 12, my lord? 12. But already petitioner has suffered a lot, my
So
lord.
that we try to understand our position. Okay, what bans it dealing with this matter?
My lord, now the 4 persons are coming. Otherwise, my lord, I am praying, my lord, only. If not reached, my lord, that is different thing. I will try my best, my lord. 12. তাতকৈ আগত দিব নোৱাৰে 12 August দিয়ক না 12
Already lot of matters.
My lord, what I meant, now this puja will start this early stage of the September, my lord, 22nd or like this, my lord. That is why again motion will start, my lord. No hearing. That is why I am apprehending, my lord. 12 August it will be better. If not, then lordship will fix another date. If not, otherwise. Ekus aguai দিয়ে I'm sorry, my lord.
Met his lordship.
Mediation, Lordship. Lordship, in this case, I leave upon the discretion of your Lordship because all other grounds are based on quantum, Lordship. But one ground we have taken is that the alleged vehicle was not involved in the accident. That was insured with our insurance company.
My lord, if I may, my lord, that my lord point was addressed in para number in page number 19 of that appeal memo, my lord. The honorable court has looked into this issue, the issue which my learned friend has just raised, whether the vehicle was involved or not. And the court has found that the insurance company could not adduce any material which would result them to say that the vehicle was not involved. So chance was given, my lord. DW1 was given by them and everything was looked into. Then the court has come to that conclusion that it is not correct. Because my lord is aware, the test in this case is preponderance of probability, my lord.
That's all right. But Mr. Day, we are not hearing the matter.
I'll understand, madam. I'll leave it. But just that this point was.
No. Now tell me whether there is any chance for reconciliation.
My lord, that will be depending upon them, my lord. If they are raising the issue of vehicle not involved, then my lord, it is probably in their hand to.
Unlikely to.
My lord, it is there
Because
to
we have
decide.
for evidence also in this case. So that is also one point.
Okay, then we'll fix it for evidence. Oh, no, sorry, hearing.
My lord, I have a small request in this case. My lord, this is a case of 2016, my lord. From 2016, these people has not gotten a single penny, my lord. Let the 50% of the amount of the debt may be deposited, and I may be allowed to withdraw that amount, my lord. That IA is there, my lord, on record.
Deposit 50% of the.
We can deposit, Lordship, but for withdrawal, let
Oh,
file a separate
bond.
IA.
I will file a bond, my lord. This honorable court will direct me. I will file I'll give a bond, which this is a practice, my lord.
The main application to say for the no purpose to third party referring the matter. I would probably that this is for hearing or audit.
Lord, please.
I take the third sort of learning council for the application. It be there or response subject it's preferred by the application. So state the judgment dated 12/2021 passed by the London Cassard short in MSc with or 07 of 2017. Appears that the MSc appeal has already been admitted and the record has gone for hearing. That is what. And taking ago, we provided that further provided that person of bank judgment that's all state subject however to payment of 50% of the awarded amount before the race. What is the amount?
My lord, it is 20 lakh, 1 minute, my lord, I'm just. It is, my lord, 20 lakhs, 4,800, page number 22 of the appeal memo, my lord. ठीक है सर page number 22.
However, this IS that's source of 4 weeks.
I may be allowed to withdraw that money.
No, Lordship, at this,
By the IS.
this.
My lord, I can do it. Just that, my lord, there is no reason to object from this matter. But I understand his. Yeah, but just that, my lord,
Because
to the
one
16
point
is.
there, Lordship, in this case. That is why we are not objecting to the deposit of 50%. But at the withdrawal, they need to file a ILO. That is.
I
the
will,
appeal period.
I will, because the order which my lord will generally will come is this, that I have to give a bond. That is the registry's procedure, my lord, that I have to give an undertaking that I will, in case the appeal is allowed in their favor, I will return that money.
No, Lordship, the ground we are taking, one of the ground is the involvement, and for that we have adduced evidence also.
You do one thing.
I'll file an IM, my lord. If,
The amount, you file an
Lordship,
my lord, please, yes, my lord. Let them be directed within 4 weeks, my lord. They're, my lord, please, yes.
Obliged.
Right, my lord.
It may be listed for the hearing. The driving license issue is there, that's it.
Or this second one, learner's concept for the is the. Yes, who is appearing for us?
I am responsible for 2 years.
I am for 1 Lord.
So send for respondent number.
I am Islam, yes, Islam.
Islam for
Respond number 2. Honor of.
respondent number 2 and Mr. Soikia
For 1 Lordship, claim it.
for what?
He will not do it.
It's submitted at the part that though the this is listed under the column there is some sort of that's the requirement for hearing. Correctly, it's provided as something for hearing process.
Obvious.
Number 6.
Lordship, our humble submission is for restoration of the claim case actually, and its adjudication on merit. And this appeal has been arising out of dismissal of MSC case number 2529 on 3/7/2017. And it was dismissed on the particular date due to the repeated adjournment because our advocate sought repeated adjournment, and due to that it was dismissed. My lord, the litigant should not be penalized and he should not be made victim for the fault of the advocate. So our submission is for a restoration of the case and its adjudication on merit. Lordship, I may take you to the page number 9, where the judgment is there, judgment is noted, point number 7.
the framing of issues. After framing of the issue, the case was posted for evidence on 16/7/2013. And since then, the claimant was taking time for adducing evidence in a routine manner. Thereafter, White later dated 11/2/16, the case was filed due to the non-cooperation of the claimant side. But on the prayer of the claimant side, the case was restored in its original file, right order dated 18/2/2016, and fixed the next date for evidence. It is a matter of surprise that even after its restoration, the claimant could not adduce any evidence. Rather, has been taking adjournment in a routine manner. On 3/7/2017, the claimant was given last chance to adduce evidence. But on 3/7/2017, the claimant has filed a petition by 2775 praying for adjournment without any valid ground. This is an old case, old pending case, and hence the prayer for the adjournment was rejected. And on, my lord, on particular that the case was dismissed. It is because of the fault of the advocate.
Whether any, you have filed any complaint and the advocate with the bar council?
So Lordship, our humble submission is for restoration of the case. And it's,
Whether you have filed any complaint against the advocate?
yes, my lord.
Where is that complaint?
It is in the IA.
That is.
Page number.
Mhm. One minute. Mhm. Page number 7 in IA, that after a reasonable gap, as there was no communication from the learned advocate regarding the case, the petitioner contacted on the learned advocate Mr. Mohesh Kumar Shah on 6/11/2020 and inquired about the status of the case. The petitioner completely reposed faith on the learned advocate and expressed his concern about the progress of the case. Then the learned advocate called the petitioner to the place, and accordingly, the petitioner went to his place on 8/11/2020.
It's a council, that is your statement in the interlocutory application, but whether you have filed any complaint against that advocate?
Yes, my lord.
Where?
Okay, that's what I'm, excuse me,
No,
lordship.
you show me the complaint.
Lordship, that fix the case for hearing, Lordship. That will be my humble submission.
You are not ready for today.
No, Lordship. Because there are several judgments today I have not brought, Lordship. Later, it will be better for them also and for us also. In the month of September, if possible.
Okay.
Because the LC has also been received.
Sir, your good name, please.
My lord,
Your good name, please.
BK Borua.
So BK Borwa, Lorded for the appellant, that's some sort of the respondent.
Respond number 1, Lordship.
That's the number 1. Do the matter is listed under the column for reference to the special mediation. addition for the yet it is submitted at the bar that no purpose will be served by referring the matter book. And the matter may be listed for like the month of September. So let's say, ninth of September for hearing.
Obliged.
Obliged. Please do that, receive.
May it please your lordship. In the IA, we have taken steps, your lordship, but service is not complete.
Not
Re-
complete.
No, my lord.
You have taken a step.
Yes, my lord. On, as per office note 4625, we have taken steps.
Okay. Third is sorry, not at home for the applicant. Office note dated 25/7/2025 indicates that office issued the respondent number R1 to R3 returned the report. No such person. No such person. Accordingly, it is provided that the learned counsel for the applicant shall obtain necessary instruction and take prescriptive upon the respondent number R1 to R3 by registered post with ATM process within a week from today. This is the matter of proposal.
Lordship, I have a prayer. Kindly, we may be allowed to take steps by dusty mode, my lord. Upon all the respondents, 1 to 5.
The learned counsel for the applicant also submits that she may be permitted to take service upon the respondent by dusty mode. They are allowed. After effecting service by dusty mode, the counsel, the applicant, the learned counsel for the fine for this court.
And my lord, in the earlier order also, the interim is continued. So my prayer is also for that. Interim may be continued till next date, my lord.
Is IH for what purpose?
Stay, my lord.
Stay.
Yes.
Interim order for certain.
Item for admission.
Obliged.
8 and 9, ordered later.
My lord, this matter is relating to the ex parte judgment and decree, my lord. And here, my lord, I have filed one additional affidavit. Certain development has taken place in this case. As the suit premises or suit land has been acquired by the government of Assam by the land acquisition notification, your lordship. And I have called the affidavit. May I read, my lord, in the meantime? Here, my lord, one notification was issued.
Your
By-
affidavit is dated.
Yesterday, we filed, my lord. It has been called, my lord.
It has not been received by the court till now.
Yes. In the meantime, it will come.
After some time.
Yes.
Let the affidavit come.
Yes. my lord.
Number 24. 24.
None against for the petition around all this the matter after 1 week.
Order item 10.
My lord, this appeal, my lord, is second appeal. My lord, that already for stayed, my lord, under order 41 rule 5, against that stay order, the I has been filed by the respondent, my lord, for vacation of stay order. That is why that case is before the court.
Lordship, matter may be adjourned for the time being.
Maybe any other day.
Hearing.
May it please your lordship. I'm for the respondent. Lordship, today this matter was fixed, lordship. So the counsel for the appellant is not there, lordship. Kindly a date may be fixed.
Okay, none appeals for the applicant also. How about with the matter on?
Obliged.
License of subsequent non-repetitive, the applicant have to pay for the support.
Paragraph 13, order.
Okay, this is with regard to whether what will be the effective date of receiving the UGC, regular UGC scale of pay.
I think so.
Hmm?
12:30.
12:30.
Lordship, in item number 13, I have received one affidavit just now. It has been filed by the petitioner.
Lordship, kindly permit me 1 minute just to bring the file also. File.
Yeah.
Lordship, in item number 13, I'm appearing for UGC. 12 and 13 are connected. In item 12, UGC is not a party. In item 13, UGC has been made as a party respondent. So in item 13, I have received just now, just 2 minutes ago, an affidavit which is being filed by the petitioner. I have not gone through the affidavit as yet. I have just received it just now.
Lordship, may kindly hear my matter because this is a 2017 matter and your Lordship has already heard. Lordship,
These two are connected matters.
that this writ petition was connected with the other matters only because of the submission by the Standing Council of the Higher Education Department.
If I have received the affidavit filed by,
Filed by the petitioner. I have just received it. It's not even 5 minutes. We have served it just now. I don't know, this affidavit in reply filed by the petitioner to the higher education department had filed one additional affidavit. This is an affidavit in reply to that.
Lordship, I am ready for my case.
so ready, but
Dada koto?
Higher education department counsel is also not here.
Also, my learned friend, senior friend is also ready to do the case today. He's also coming. He has given instruction that I may start with my case. Then he will. Yes, my learned senior friend is there. Oh.
My lord, I have filed one reply to the affidavit filed by the Madam. But I have today I have filed, my lord. Actually, yesterday that was filed, but due to the non-availability of the UGC Standing Council, that was not served. But so we have served today only. So one short date may be given, my lord.
or that
Yes, madam.
the technical government has to put the part this is the method. Okay. Last part of August.
21st. Yes.
21st.
Massive.
Pledge lodge.
All right.
Item 18 is the woman daughter.
Your lordship, item may be passed over for time being.
Why?
My senior is lexing in another court.
Who is your senior?
He's in Central Administrative Tribunal.
No, who is your senior?
Oh, is it Dr. G.J. Sharma? Respondent number 20.
Okay.
May I please, your lordship? My lord, the respondent filed a title suit before the learned Munship Court at Gwalpara. Lordship may kindly see page 14. And Lordship may kindly see the boundary, page 17. North Saburuddin Sheikh, South Solimuddin, East PWD Road,
Yeah.
West Solimuddin Sheikh. This is the boundary of his claimed 1 bighas of land. Now, in this case, in this suit, I got summon from the learned court, but I did not appear. I wanted to appear, but someone instructed that you need not appear because your land does not cover this boundary. So in that manner, I did not appear. And the suit was decreed ex parte. The matter proceeded with title execution case. When the execution case started, my lord, at that time, it was seen that his land is totally different plot of land covered by different boundary. In such a petition, but he wanted to take over my land. Now, Lordship kindly see page 33. Page 33.
There may be difference of this boundary, but is there any discrepancy in the tag number and pattern number?
Dagnamar Patama, I am coming to that. There is an inspection report by the circle officer.
You please answer me which one? Is there any difference of tag number and pattern number?
That, my lord, is not clear. But thing is this, that land is nearly 1 kilometer away. My land is 1 kilometer away from his claimed land.
I am not asking you about the distance. I am asking you about the tag number and pattern number. Whether there is any discrepancy.
In the present patta, which has been annexed here, his name also appears, my name also appears.
That pattern number is same, lordship. There is no discrepancy in that number and pattern number.
Let me submit first.
Yes.
You are referring to page number 33.
33.
Yes. You have filed an application under section 47.
Yes. That the plaintiff filed TS number so and so, plaintiff means respondent, for declaration of right, title, interest, and recovery of suit land. The TS number so and so was proceeded ex parte against the defendants and decree holder obtained decree in TS number so and so. That the suit land shown in the schedule of the plaintiff is vague and ambiguous. That the suit land has no connection with the land of the petitioner, but in the name of taking possession of the suit land, the decree holder is trying to take possession of the land belonging to the petitioner illegally. That there is question regarding execution, discharge, and satisfaction of the decree. So it is therefore prayed that your honor would be please register a case under section so and so so and so. This petition was filed, my lord. They filed written objection. That is page 35.
Yes.
Then learned court passed the order, that is page 37. on the basis of our objection and their objection, learned court passed the order. Kindly see the last two paragraph, page 37.
So this is the impugn order.
This is, no, that is not impugn order. Impugn order is different. Kindly see the court is changing its mind every now and then. I will bring it to a notice. Now, page 37, kindly see, considering all, I find that as the boundary of the decretal land is in dispute, setting up a commission will be utmost essential for determining the matter in controversy by this court. Thus, in the light of section 47 of CPC, the instant petition is hereby allowed. That means our petition was allowed. Judgment Deputy is hereby directed to do the needful for setting up of a commission for.
Mr. Mahmood, your petition was for setting up a commission. Is it?
Sorry, madam.
Your prayer in the petition was for setting up a commission.
Commission for ascertainment of the real land.
That was your prayer in the petition.
And that was, that it is not our land, so it was dismissed. That was not there, but court considered, after hearing both the petitions, that setting up of a commission is necessary to identify the decretal land. So court also came to judgment that is hereby directed to do needful for setting up of a commission for proper identification of the suit land.
What happened thereafter?
Thereafter, my lord, thereafter, the matter was sent, kindly see now page 40.
Page number?
40.
Yeah.
Here the landed Munshif is sending letter to Assistant Settlement Officer, Lakhipur Revenue Circle, Lakhipur, whereas the judgment debtors filed a petition before this court stating that the decretal land does not carry the scheduled land. Therefore, it is hereby asked you to make an inquiry regarding the existence of the below mentioned land. So, and to submit report before this court on or before so and so. A plot of land measuring 1 bigha pertaining to patta number 94, covered by dag number 254255, situated at Revenue Village, Rakhal Killa, under Lakhipur Circle within Goalpara district. You are also directed to clarify whether above plot of you have founded as follows. Not so within what I have read. So, court asks the Assistant Settlement Officer to measure the land locally and whether this boundary covers the suit land or not. Clear report was called for. 40. Then their petition is there. They filed petition, execution petition. And execution petition, Lordship kindly see page 43. Same boundary. They are claiming what they wrote in the title suit. Same boundary. Now, the report is coming from the ASR. Page 47. It is the report of Mondal. It is submitted to ASO. Report regarding the order of Honorable Munshif number 1, that is so-and-so, passed in title execution case number so-and-so. With due respect and in the context of the aforesaid order, after inquiry, it is seen that in village Rakhal Killa, under Lakhipur Revenue Circle, all patta number 94, new patta number 136, and all dag number 255, 254, 255, new dag number 299, 293, total 1 bigha 17 lesser land stands in the name of one Jolibur Rahman, 2 Zobeda Khatun, Bibi, 3 Johurul Haq, I myself. for Fozorally respondent. So in the same patta and that there are several parties land. Now the boundary of the said land as appears at present, there is no similarity seen. The boundary of the said land appears at present, there is no similarity is seen. After local investigation, it is found that boundary of the said land at present as follows. North Umedali. Now can you see gulf of difference? Gulf of difference. Here, can you for a moment take 43 and 47. 43, which they claim North Saburuddin Sheikh. 43. Now can you come 48, 47, bottom. North Umaid Ali, Hakim Ali. Lashmi has seen? In 43, his claimed land is North Saburuddin Sheikh. But here, it is Umaid Ali and Hakim Ali. Then they claim South Solimuddin. Here South is Solimur Rahman.
They are said person.
No, they are not same person. Now, can you see East? Here, they wrote East PWD wrote here, East Aminul Haq, Nur Islam, Afial Haq, Sofial Haq, son of Hussain Ali and others. West Village Road. And here, their land was West Solimuddin. So there are dangerously different plot of land. No tally at all. Now, on the basis of that report, the report was prepared in presence of both the parties. Kindly see page 50. Signature of witness, Abdul Motleb, number 2, Fazur Ali, the respondent. He was also present there. And 3, Nur Alam, 4, Johurul Haq. Johurul Haq is I myself. So both the parties are here, and in that the boundaries were measured, and it is found totally different than. So for the kindly see now the second paras, I am reading from today on 14/1/2016, as per what the warrant, I went to the decretal land and told the decree holder to show the land, and he showed me the land, but boundaries of the land mentioned in the warrant does not tally. On the other hand, to execute the warrant of possession of, with the help of Latmandal has become necessary. So for the above reasons, I could not execute the warrant and return to the Honorable Court of necessary order. So it is written by Dhruvajyoti Sutradhar, who is perhaps his title is not written, but I think he would be Sestada. Now my submission is this, my lord. They have got the decree in respect of particular plot of land, to which we have no objection. It is not their case that after lapses of time, boundaries have been changed. This is not their case. Sometimes boundaries are changed because earlier was Mr. X, later on the same was purchased by Y. But it is not their case. Their clear case is always that this is our boundary, this is our boundary, and that was since the 2010. Now they totally different, and that's why I did not contest. Because if they got the decree, if they get the decree, we have no objection. But in the name of that decree, they want to take my land. So argument will not change the nature of the claim. It is mentioned in the schedule of the.
Thereafter, what happened?
Thereafter, my lord, the learned Bookship, though he sent the report, but surprisingly, the learned Munship changed his version. Kindly see page 38. He himself called for the report, but he is again going, this is again the judgment of our High Court, that if a report is called for, suppose a person has submitted a matriculation examination, and there are some error, some doubt, the matter is sent to a SEBA. SEBA certified that ATC is genuine, that it is the mandatory duty of the officer to accept it. Because then what was the purpose of sending it to SEBA? Similarly, when the matter was written to ASO, ASO submitted report boundary does not tally, and in the same patta, in the same DAC, both parties' names are there. Now, even then, learned Munshif, against his own orders, passed this improvement order, page 38. Both the sides are duly represented. Today, fixed for order. The judgment order has stated that decree holder has obtained a degree in case number so-and-so and Iman, following which writ was issued, but that the boundary of the decretal land is not similar with that of the actual land, and thus, on the prayer of the judgment debtor, a commission was set up for the identification of the decretal land. According report is received. I have perused the report and have also gone through the case record. The result of the report transpires that decree holder's name is entered in the record with respect to the decretal land. The report further reflects that boundary of the suit land on the date of demarcation is different than the boundary at present. Now, my lord, here, this is the creation of learned court. They did not file any petition. By passage of time, the boundaries have been changed. The learned Munshi Somoto is saying that different than the boundary at present. Now, where he got it? Where he got it that boundaries was the boundary at present? Now, in view of the report submitted, I do not find the objection of the judgment debtor to be sustainable, as it is apparent from the report that the decree holder's name is found to be recorded with respect to the suit land, and only the boundary is different. My name is also there. Lordship. Zohar Haq's name is also there. So, and only the boundary is different. This is very important. If the learned Munshi Somoto discovering some matters, it is opposite to mention herein that the length of an average civil trial cannot be ascertained easily, and there is very possibility that during the proceeding of the suit, the boundary of the suit land might have changed. These are all the creation of learned Munshi. This is not their case. Yes, I know. By passage of time, some boundaries may change, but that should be brought to the notice of the court, and court shall have to hear us. Then only some observation may be given. But here, without any petition from the respondent side, that is the plaintiff side, the Munshi is saying like this. And then Lordship would kindly say, lastly, he is saying in the second part, I am of the opinion that there is no dispute regarding the boundary of the suit land. Very dangerous opinion, man. When the practically both parties are there, Mondal when their Sessadar was there, public were there, both parties were there. At that time, but the learned Munship says, I am of the opinion that there is no dispute. How? There is dispute. It is on record. How beyond record he can say there is no dispute? ASO has sent the report. Yes, there is no similarity. So, my lord, on consideration, so lastly, this order we have challenged. Our submission is only this. They have got a decree. Let them enjoy the decree. But if, my lord, I am telling the provision of law, now section 47 and section 152, if there is any difference while the case was pending, then decree may be amended. But that is not their case. They did not file any such petition. They are insisting, yes, we will take your land. That is not the law. If digital land is, there is some dispute or due to lapses of time, passage of time, the boundaries have been changed, the petition should have been filed under order 47 and section 152 of CPC. That was not done. So, Honorable Supreme Court said, my lord, that kindly see para 45. It is clear that para 45. It is clear that there is not the executable.
Mr. Mahmood, where the other pages are?
Only relevant person is given, my lord. Only relevant paras have been provided.
Not the good.
What? Then
All the relevant pages.
one important observation is that, my lord may kindly say para 51. That is a highly important observation of the Honorable Apex Court. There could be no doubt that a decree should not be the extent, should not to the extent practicable be allowed to be defeated. At the same time, a decree can only be executed in respect of the suit property if the suit property is easily identifiable. Easily identifiable, no research is necessary. Who was not 5 years back, who was not 10 years back, this type of research work is not necessary. Supreme Court says that easily identifiable. Here is easily far away, do not tally at all. At all.
No, boundary may not be tally with the schedule of the client. But is it your case that the land is not identifiable?
No, not identifiable because that is 1 kilometer away.
That number, pata number is same. Only to some extent there is a
Not to
discrepancy
some
in the
extent,
not ID.
to major extent. All the 4 boundaries are different. Not to some extent, my lord.
No,
All.
no. It's not about the question is whether the land is identifiable. On the basis of this that number, pata number.
Well, how land is identifiable? Because land would be identified.
It has to be answered by the revenue authority, not by you.
The executive court has power, and executive court observes something which is beyond record, and that is not their case. That by passage of time, boundaries have been changed. Suppose, my lord, for a moment, my lord, I am taking your lordship to this honorable high, North River Brahmaputra. If someone reads it is not Brahmaputra, it is Buridia, then how it will be Tali? And south, there is the PWD road. In south, it is written, it is the land of Jogesh Das. Then how it will be executed? Then, my lord, every degree will be executed over the land of any person. If the patta in the
Pata number is same.
Dagnam or patta number same in that Dag and patta, I have also land. Kindly consider this. In that Dag and plot, I have also the land. But boundary will tell his land, boundary will say my land.
Okay, yeah. What is your case?
Kindly appreciate.
Please sit down.
Lordship, kindly come to page 6, para 4 of the petition, Lordship.
Yes.
Page 6, para 4. I'm reading the 11th portion, Lordship.
Yes.
This plot of land was purchased by the present petitioner and his deceased mother, Jabeda Khatun Bibi,
on 13/1/1882 by dint of a registered sale deed number 1 so and so dated 13/1/82. That deed was never produced at any point of time, Lordship. They have got ample opportunity. They got the someone in the title suit. If this is their land, the deed never produced that sale deed. That would have cleared the position, Lordship. They are claiming by virtue of this deed. But they did not produce it at any point of time. Till now, they did not produce this deed. What is their boundary? Actually, they did not disclose. Only the claim is that boundaries are defined. But it's a DAG number and pattern number are same. My name is also there in the record. They even till that they did not challenge the mutation of my name also. Did not challenge. Now only for that reason that the boundaries are different. This is the observation of the court that by the passage of time, boundaries may be defined. This is the court's observation. But the DAG number, pattern number are same. So they got their someone in the title suit. They took APR, took time to file WS, then they did not APR. Accordingly, the title suit proceeded ex parte. Ex parte decree was passed. We have filed an execution. In execution also, they got the notice, took time to file written objection, but they did not APR thereafter. Accordingly, writ of possession was passed. Then they filed a petition that is which they this is their petition at page 33, Lordship, claiming the suit land is vague and ambiguous. Claiming that the suit land is vague and ambiguous.
Page number?
Page number 33 of their petition, Lordship.
Yeah.
That petition was numbered as 21/16, Lordship.
Yeah.
That was dismissed on by order dated 30/11/17. That your Lordship will find in my evident opposition at running page 60. My affidavit in opposition. Kindly see the observation of the court, Lordship.
Page 60.
60. Annex 13.
Yes.
May I read the relevant portion, Lordship? Page 63.
Yeah.
Considering the above facts as well as perusing the original case record of the title suit number so and so thoroughly and distinctly, it transpires that decree holder filed the title suit for declaration of right, title, interest, and also for recovery of possession of the suit land against the defendant, which has been registered as TS number 123/10. And as per provision of CPC, summoner issued to the dependent judgment debtor, and on so and so dependent judgment debtor appeared to court through its counsel and sought for time for submission of written statement. However, on so and so, the judgment debtor remained absent without any step, and as a result, the case proceeded ex parte against the defendant side. And while order dated so and so ex parte order was filed by the then landed Muslim number 1 Golpra, and on 19/7/11, decree was prepared, signed, and sealed. However, on 15, decree holder plaintiff filed a petition before the court to execute the decree of TS number 12310, and the said petition was registered as title execution number 3 of the 15. And as per provision of law, summon was issued to judgment debtor, and on the 22/7/15, judgment debtor appeared before the court and again sought for time for submission of written objection. But on 14/10/15 and on subsequent dates, judgment debtor defendant remained absent without any step. As a result, by the order dated 21/12/15, writ of possession was issued against the judgment debtor. However, on 29/16, judgment debtor suddenly appeared before the court and filed the instant petition and prayed before the court to dismiss the execution proceeding. On the ground of suitless, vague and ambiguous. Now, the first and foremost duty of the court is to determine is that whether decree holder had fraudulently mentioned a vague and ambiguous schedule of land in his plan, which has no connection with the land of the judgment debtor. In such a scenario, it was the duty of the judgment debtor to establish the said fact at the earliest time when the decree holder plaintiff filed the title suit against him, but farmer remained absent without any step in the said title suit case, and subsequently on 12/7/11, ex parte order was passed against him. However, judgment debtor, even after passing the ex parte order on 12/7/11, did not raise any objection, any contention before the court, which has passed the decree, nor preferred any appeal before the superior court to set aside the ex parte decree and remain dumb for a long time. And even after receiving summon on 22/7/15 in the instant execution case, judgment debtor remained silent and did not raise any objection, but for the first time, judgment debtor raised the matter when writ of possession was issued against him, as later remained absent without any step. From the above fact, it is to be held that if there is any such objection, it is to be raised at the earliest point of time and not at a belated stage when decree holder is ready to enjoy the fruit of labor. Thus, it can be held that judgment debtor has not come to this court with clean hand, and as such, prayer of petition number 21/16 filed by the judgment debtor is dismissed with a cost of ₹2,000. And as such, order dated 29/2/16 is set aside, and decree holder is immediately directed to take a step of the writ of possession. So their earlier petition was dismissed, Lordship. Thereafter, they filed a petition setting up a commission which is numbered 56/19. Page 37 of their petition is the order passed in petition number 56/19. Setting up the commission, Lordship. And finally, after page number 37, against their application number 56/19, the executing court set up a commission to identify the suit land. And then after submission of the report by the commission, the impugned order was passed, that is on page 38, Lordship. By this order, the learned court has observed that there might be a change in the boundary of the Surya by the passage of time. here may I read lordship. From the second para. Perusal of the report transferred that the decree holder's name is entered in the record with respect to the decretal land. The report further reflects that boundary of the suit land on the date of demarcation is different than the boundary at present. Now, in view of the report submitted, I do not find any objection of the judgment debtor to be sustainable, as it is apparent from the report that the decree holder's name is found to be recorded with respect to the suit land and only the boundary is different. It is apposite to mention herein that the length of an average civil trial cannot be ascertained easily, and there is every possibility that during the proceeding of the suit, the boundary of the suit land might have changed. Only for this point, they have come to this honorable court. Before that, they did not raise any objection. They had got ample opportunity, lordship. Even in their petition, which they have claimed that they have bought the suit land by dint of a registered sale deed dated 13/1/82, that sale deed was never produced before the court to lordship. If they produce this deed also, then so both the land could have been identified by the revenue official. They did not produce it. The boundaries are same. Even they did not challenge the mutation of our name in the decretal land. Now, only because the boundary may not defined at present, they have disputed that these are totally different. Now, here question is only identifiability of the land, lordship, decretal land. Not be Order 7 rule 8 lordship, identifiability of the suit land. Where the subject matter of the suit is immovable property.
Rule?
Order 7 rule 3.
Yes.
Where the subject matter of the suit is immovable property, the plain shall contain a description of the property sufficient to identify it. And in case such property can be identified by boundaries or numbers in a record of settlement or survey, the plain shall specify such boundaries or numbers. So that number and pattern number of the decretal land is same. It can be easily identified. Only because the boundary may not defined at present, it does not mean that the suit land cannot be identified. So this petition is nothing but only to delay the execution proceeding, lordship. And kindly see their prayer, lordship. In the premises apposite, it is therefore most respectfully prayed that your lordship may graciously be pleased to call for the record, issue a rule upon the respondent to show cause as to why the order dated first in title suit number 7 shall not be set aside and quashed, and or to show cause as to why the order in decree dated 12/7/21, 11, passed and prepared by the learned Munsip Goalpoint title suit number 123/10 shall not be set aside and quashed. Lordship, the judgment and decree has got its finality, Lordship. That did not challenge the judgment and decree. Now they are praying for setting aside of the judgment and decree, Lordship. After 12 years, decree has been passed and prepared in 2011. Now they are praying for setting aside of the judgment, which has been already got its finality.
Okay.
One
Not anything to.
3-point reply, my lord. First thing, my lord, my learned friend has said, regarding the provision of CPC, complete description of the suit land. So here description is totally wrong. Number 2, my lord, we have sought the decree to be cancelled on the ground that the lands is totally different. Thirdly, in the patta, same patta, our names are also there. So, it will be a very dangerous practice that if all the boundaries are not tally, even then another person's land is taken in the name of decree, it will be a dangerous thing in society. Now, he cannot stand on my leg. He shall have to prove his own case by convincing evidence.
Mr. Pamod, you see, you have never contested the proceeding.
Yes,
Trial court.
right.
And the decree and judgment passed by the learned trial court attained finality.
Yes. Yes, that is to be executed. I have no objection on that. But at the time of execution, he is going to my land. Then I file petition. Then is set up commission. Commission said, yes, decretal land is totally different, does not tally. Then how the decree would be executed? Supreme Court says it should be easily identifiable. 4 boundaries are different. All the 4 boundaries are different. It is not their case.
Mr. Pamod, now the question is whether, in spite of the discrepancy in the description of the boundary, whether the land can be identifiable on the basis
Never.
of tag number.
It cannot, it can never. Tag number, patta number, my lord.
You see, even on the authority to decide this.
No, I am not the authority, but the authority is the law, man.
Authority
Law says
is
easily identifiable.
Authority is the revenue authority. They will see whether the land is identifiable or not.
ASO is the revenue authority.
Pardon?
ASO, Assistant Settlement Officer, is revenue authority. So far, my learned friend is saying regarding mutation, my lord. Mutation is not the proof of title. Only for payment of receipt, revenue.
No, so it may be applicable in your case also.
Yes. So, suppose their names are mutated. Let them enjoy their own land. I am also, my land is also mutated in my name. I am enjoying that I am paying land revenue. But now question is execution of 1 bigha land in a place which is nearly 1 kilometer away, if his boundary is taken up. So his boundary, and that is totally different. In my petition, I have mentioned how he can take a totally different boundary. Kindly consider this aspect, very serious matter, my lord. This Honorable High Court is the court of record. If 4 boundaries do not tally, and they have no case, my lord, they never say that during the passage of time, boundaries have been changed. They can do it. And now they can also, at present also they have way, my lord. That is petition under Order 47, Rule 152. They can amend the decree. Instead of amending that, if the decree is executed in a wrong manner, that I leave to your lordship. I remember a judgment of my Lord Justice Decca. He said that that without amending the decree, and if the boundaries are different, decree cannot be executed. They have way. They can file petition, get their decree.
Okay, we'll see. Third is a common lot of order there.
Obliged.
22.
May please your lordship. The present petitioner, appellant, my lord, S 25, title suit matrimonial number 143 of 2015, before the Learned Court of Additional District Judge, first number 2 at Inchikia, my lord, praying for a decree of divorce, my lord. And the respondent contested the case, and the appellant as plaintiff filed evidence on affidavit on 6/8/2022, my lord, para number 6 of petition. The case the date was fixed for cross-examination and of the plaintiff witnesses, and on the very date, my lord, the respondent defendant filed petition number 802 of 2022, praying to call for some record from other court, my lord. More particularly record from of title suit number 32 of 18 and miscase number, as well as record of miscase number 41 of 2018, my lord. Two records were. So the petitioner appellant filed objection against them, and matter was fixed for hearing on various occasions subsequently. The petitioner has completed hearing, my lord, as in the case on the petition, my lord.
This order dated 15/12.
Yes, I am going to that. Yes, my lord. I am going to that effect, my lord. But the ultimately hearing was not completed on the very petition, very case, my lord. But on 31/5/2023, the case was fixed for hearing. That means hearing means on the very petition, petition number 802 of 2022, my lord. But on the very date, the plaintiff appellant was found absent, and for which the Learned Court below, by order dated 31st May of 2023, Annexure 5, my lord, dismissed the whole case, my lord. Annexure 9, my lord, at page 54, my lord. Petitioner is absent without taking any step. Respondent is represented by the learned advocate. Earlier, this case was dismissed by order dated so and so for non-prosecution by the petitioner. Case is dismissed. Actually, the case was fixed for hearing on the petition, my lord. Petition number 802 of 2022, my lord, on which date was fixed for hearing. But Learned Trial Court below dismissed the whole case on that date, my lord. So, after dismissal of the suit, my lord, the learned advocate for the appellant plaintiff filed a petition for restoration of the case, my lord. And that petition was also dismissed by order dated 15/12/2023, my lord, Annexure 12, my lord, at page, my lord, 65 to 68, my lord.
So you have referred to first order dated.
My lord.
First order.
First order dated, my lord, 31st May of 2022.
Page number?
Page number 54, my lord, Annexure 9, my lord.
54.
Just now we have read it.
Yeah.
I was absent, my lord, on the very day. But actually, the case was fixed for hearing on the petition, my lord, not on the case, my lord. Prior to that, my lord, annexes 7, my lord, kindly peruse it. Page number 50, my lord. Both sides are represented, part heard the matter. Our part was completed, my lord. In our petition also, my lord, for restoration, my lord, we have specifically mentioned that on the very date, my lord, the case was fixed for hearing on the petition. But the learned trial could below, without considering that aspect, dismissal of restoration petition also. By the impugned order, my lord. Operative 15/12/2023, operative part 66, my lord, this now. There is no whisper regarding the petition. Petition number 802 of 2022, my lord.
Which one number?
Page number 66, my lord.
Yes.
That is the first, second impugned order, and first impugned order, my lord. My lord, at page 9, page 54, my lord, page 9. Parties are absent without taking step. On the very date, the case was fixed for hearing on the petition, my lord. Not for hearing on the suit, my lord.
Yeah, we will resume after 5 minutes.
My lord. My lord.
Yes.
My lord, indefinite, my lord, I'm sorry to say, item number 24 was for in morning time, my lord. At that time, I was not there, my lord. So there is an interim order till today, my lord. So it will continue. 24. Procedural.
So, my lord, the learned trial will below, without considering the fact that the petition number 802 of 2022 was pending and picked the matter for hearing, without considering that, dismiss the whole suit, my lord. By the first impugned order. That is the main problem involved in this case, my lord.
Pardon?
Yes, my lord. By the first impugned order is, my lord, Annexion 9, my lord. Page, my lord, page 54, my lord. 31st May of 2023, my lord. The matter was actually fixed for hearing on the petition, my lord. Petition to call for the record, my lord. And that petition was filed by the respondent, my lord. Respondent defendant.
That petition number 80.
My lord.
Petition number 80.
Yes, my lord.
That petition is the page number?
Yes, my lord. The petition is, I have not annexed, but order is at 68, page number 41, my lord. Yes, my lord. Petition is annexed.
Page number?
42, my lord.
42 is the petition.
Yes, my lord. Sorry, my lord. The order is 41, my lord. Petitioner is represented and filing a petition number 78982 of 22. Hard prayer is allowed. A respondent, that petition. A respondent has filed additional written statement and praying for dismissing the case and pass an NO. Also seen the petition number 802/2022. Hard prayer is allowed. Keep the petition till filing of objection on petition number 802. Next date 22/8/2022 for objection, my lord. We have filed objection, my lord. Annexure 546, my lord, page number.
What is your objection?
My lord, Annexure 5, page 46, my lord. Written objection filed by the petitioner against the additional written statement dated so and so, and the respondent under order under order 8, rule 9 of CPC, read section 151 of CPC. And
Yes,
next,
Mr.
next
Gupta, what is
20,
what is your
24,
stand?
Due order. Due order is at page 65. And relevant will be, my lord, it starts from page 67, my lord. Page 67, my lord, I'm reading from the last paragraph, my lord. That is the finding of the court, my lord. I have carefully gone through the provision of Order 9, Rule 4 of CPC under the said provision of law. It is specifically mentioned that whereas a suit is dismissed under Rule 2 or 3, the plaintiff brings a suit or he may apply for an order to set aside the dismissal aside. And if he satisfied the court that there was sufficient cause for such failure for his non-appearance, the court shall make an order setting aside the dismissal. Here in this present miscase, the said application of this case is not signed and verified by the petitioner himself, as per rules of Honorable Guwahati High Court, and no any sufficient ground to support the contentions of the petition has been substantiated by any documentary or oral evidence on behalf of the petitioner. And on entirety, the petitioner failed to prove his case and satisfy this court regarding his non-appearance on the date when the suit was called for hearing. For non-appearance of the petitioner, the suit was dismissed. In view of the matter, I found no merit in the instant case, as such it is dismissed. My lord, what happened in this case, madam? After dismissal, the petitioner has filed one mistake case, madam. That is at page, my lord, page 56, madam.
No, that whether that dismissal order is not challenged here.
In this petition, my lord, no, madam.
The first dismissal order was not challenged.
No. Even, my lord, the copy supplied to me, my lord, I do not find any prayer, my lord.
there is learned trial court below, Annexure 6, page 49, my lord. Fix the matter initially for hearing on the petition, my lord. Petitioner is represented, respondent is absent without any step fixed for necessary order and further hearing. Hearing on petition was commenced, but not completed, my lord. So it was the duty of the learned trial either to allow or reject their petition. 802 of 2020 could not dismiss the whole suit, my lord.
My lord,
That is the problem,
my lord,
involved in this case, my lord.
The court below has, my lord, rejected his petition. My lord,
After all, it is a matrimonial case, my lord, between husband and wife.
my lord, the petition of the petitioner was mainly rejected, my lord, on the technical ground that this petition mistake case, my lord, that is at page 56. And my lord, affidavit at page 60, my lord. Page 56 is mistake case, my lord, filed for restoration of the suit. Page 56. And my lord, the lordship may kindly come to page 60, my lord. That is the affidavit, my lord. My lord, it was sworn by the counsel of the petitioner, my lord.
Yes.
This affidavit was sworn by the counsel of the petitioner, my lord, not the petitioner, my lord. And my lord, Order 6, Rule 15 of CPC says, my lord, every pleading should be verified by the person who is filing the petition, my lord. Because not only the facts, my lord, many things are stated in this petition, my lord. The counsel has sworn the petition. Mainly on that ground, And my lord, apart from that, my lord, nothing was produced before the court. That she has posted a date wrongly or anything, my lord, nothing, even her diary was not produced before the court, my lord. So on these two, considering these two aspects, my lord, the court has rejected the petition.
Affidavit was ordered by the council.
Counsel, my lord, is if lordship 60, page 60, my lord, although it was not filled up properly, but paragraph 1, my lord, that I am the counsel of the petitioner of the instant application, and as such, I know the facts and circumstances of the case very well, and thereby I am competent to swear this affidavit. My lord, no verification, nothing, my lord. Even the verification from the petitioner ought to have given, my lord. Mainly due to this, my lord, on technical grounds, this petition was rejected, my lord. And my lord, their case is that, my lord, the counsel of the petitioner wrongly, while posting the date in the diary, wrongly posted the date, but neither the diary was produced nor anything was produced before the court below, my lord.
Diary was annexed, my lord.
Here he has annexed, my lord, but before the court below, nothing was produced. She could have produced her, she could have produced her original diary before the court, my lord.
Her facts remains that case was fixed for hearing on the petition.
My lord, this petition ought to have been filed by the petitioner, my lord, not by the counsel, my lord, because we plead on behalf of our party, my lord. We do not have any personal knowledge of all the.
The question is whether because of the fault of the advocate.
That is there, my lord. That is there. I leave to your lordship, my lord. But the only thing, the court has not gone into all this, mainly on technical grounds. This petition was rejected, my lord.
Set aside for the order, let the parties appeal the trial court. Within a period of 1 week from today.
No, let it be after 1 month, my lord, because I have to communicate and all this.
1 month.
Yes, my lord.
Okay.
Yes, my lord.
Okay. Last point. Both the parties shall appear before the trial court of that day.
Yes. All right.
Coming items, second line.
My lord, this matter is relating to the ex parte judgment and decree passed by the learned court below. And now certain new development has taken place in this case, my lord. The scheduled property, my lord, has been acquired by the government under the Land Acquisition Act. So I have filed the additional affidavit, my lord, and I have annexed the notice, copy of the notice. And here, my lord, I have quoted the relevant portion of the Land Acquisition Act, paragraph 4, my lord. That the petitioner begs to state that the government has become the owner of the scheduled property by operation of law in view of the provisions of section 6, 2 and 3 of the Assam Land Acquisition and Acquisition Act 1964, which reads as follows. Where a notice as aforesaid is published in the official gazette, the requisition land and premises shall on and from the beginning of the day on which the notice is so published vest absolutely in the state government free from all encumbrances, and period of requisition of such land shall end subject to the provision of this act on such vesting. The provision of Land Acquisition Act
with the rules framed thereunder shall so far as may be applied to such land. So, my lord, this instant suit initiated on the basis of the land in question, as the respondent was the owner at that time. Now respondent is no more owner in the eye of law. So the basis of this suit has gone. So now your lordship may kindly, in my affidavit, paragraph 7, my lord, your lordship may kindly see I have quoted the relevant portion of the judgment of the Honorable Supreme Court. That it is respectfully submitted at the Honorable Supreme Court in the case of so and so in para 32 observe as follows. In Badrinath versus Government of Tamil Nadu and others, AIR 2000 Supreme 3243, this court observed that once the basis of a proceeding is gone, all the consequential actions, orders would fall to the ground automatically. And this principle of consequential order, which is applicable to judicial and quasi-judicial proceeding, is equally applicable to the administrative order. See also the state of Kerala and so and so, so and so. So the basis has gone, the suit will fall. When the foundation is removed, the superstructure is bound to fall. This is the principle. Applies here also, my lord. And moreover, my lord, I am referring this right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. And I am referring this
That's all right. When the notice was published,
notice, my lord, date is not available in this notice. This is the difficulty, my lord. I have annexed, your lordship may kindly see. The date we have to ascertain, my lord. That is why we are.
no, when the acquisition notice was published,
The date is, this is there. Date is not available. So I wanted to ascertain the date, but it will take some time because here it is not there.
page number, have you enclosed it?
Yes.
Page number?
Page number, my lord, in additional affidavit, my lord. Page number 6.
Additional affidavit filed today.
Today, my lord.
Page number?
Page number, my lord, this 4. 6, my lord, 6. Form C. This is issued from the Deputy Commissioner, so therefrom we can get, my lord, the date. So that we have to ascertain. We will take some time to ascertain.
You have to go to the authority who had issued this notice.
Yes. So it will take some time. Recently, 2-3 days earlier, we got this information from the petitioner. Some time may be granted. I will get because date is important, my lord. I wanted to see also the date, so that in the meantime we can get the further information from the Deputy Commissioner, and we will file in the additional affidavit.
But prior to the date of acquisition, you have to pay the area rent.
Area rent, I am paying the rent, and they are also withdrawing the rent. Only the default period is the April 2010 and July 2000. This is their pleading. Only for 2 months. 2 months I am ready to pay. Already we have paid, but again, if your lordship direct, I can pay twice also.
Why should I direct you to pay twice?
Yes, because I have already annexed the relevant documents. Check was given. NJ case number is there. And they are withdrawing. It is their statement also. Through they are refusing, we are depositing in the court, and they are withdrawing. Not a single paisa is due to me.
My lord, this
Concerning the date of this notification,
lordship, actually, yes.
do you have any idea about the date?
No, my lord, I also do not have any idea exactly. My lord.
Then what to do?
It says LA case number 9 of 2025. So invariably, this will be issued in 2025. My lord,
Recently.
my humble submission before your lordship will be, since lordship has already indicated, my lord, in the plaint, if the plaint is perused, in the prayer portion of the plaint, my lord, the plaint, if you, it starts from page 36, my lord.
Yeah.
Page 36, the suit was instituted in the year 2010, my lord. In the year 2010. And under the provisions of Assam Urban Area Rent Control Act, my lord. Since he was the defaulter in payment of rent, my lord, it was for his ejectment from the rented premises, area rent and compensation, my lord. I would like to draw your lordship's kind attention to the prayer portion, which is at page 42, my lord. Page 42. Lordship, prayer A, for recovery of area rent of rupees 1,25,592 only from the defendant. B, for ejectment of the defendant from the suit premises. C, for compensation from the defendant for his unauthorized stay in the suit premises after 31/3/2010 at the rate of 5,000 per day along with mesne profit for all the cost of the suit for other reliefs of the plaintiff. Now, my lord, with this particular suit with prayers made therein, my lord, was duly considered by the learned trial court in the judgment which was delivered, lordship, way back, page 79, my lord. It starts, the judgment starts as page 79 on 5th of December 2020. On 5th of December 2020, and the operative portion of the judgment, lordship, will find in page 89, my lord. I'm not troubling your lordship with the other findings because it is not a court of appeal now. Lordship is taking up revisional jurisdiction, so I'm not troubling your lordship with other facts. And since my learned friend's prayer is confined to only that much, my lord, order, my lord, 15, paragraph 15, page 89, my lord.
Yes. Yeah.
In the result, the present suit is decreed on contest with cost in favor of the plaintiff. The plaintiff is entitled to recover area rent of rupees 1,25,592 from the defendant legal heirs at present. The defendant legal heirs at present are liable to be ejected from the scheduled premises by following due process of law. The plaintiff is entitled to get compensation from the defendant for unauthorized stay in the suit premises after 31/3/2010 at the rate rupees 2,000 per day till realization of the decretal amount. Decretal amount is, my lord, 1,25,000. This legal position has not changed anywhere, my lord. My learned friend's submission that he was depositing rent in court, where there is no judicial finding to this effect. The learned trial court has, after examining all the evidences on record, have come to the conclusive finding in the form of a judgment and decree that at area rent of 1,25,592 is due from the defendant, that is the petitioner herein, to the plaintiff. This legal position was affirmed in the year 2020 itself. Just because the state of Assam has now issued a letter, issued a notification, or in 2025 that the land will be acquired, this dual relationship between the tenant and the landlord has not changed in any way, manner, my lord. Because this has rather been fortified, first by the passing of the judgment by the trial court, which was again reaffirmed by the appellate court, my lord, in appeal. In the appellate court also, my lord, if your lordship peruses page 111 and 112, my lord, if your lordship, the operative portion of the appellate court's judgment, my lord, which was delivered in the year 2022, that is also prior to the notification of land acquisition. The appeal is dismissed on contest with cause. From the findings of the issues which are upheld by this court, I am of the view that the respondent plaintiff is entitled to recover area rent of rupees 1,25,592 from the appellant, and the appellants, their agents are liable to be evicted from the suit premises by following due process of law, and the respondent is also entitled to get compensation from the appellant for unauthorized stay in the suit premises after 31/3/2010 at the rate of 500 per day till realization of the decree amount instead of 2,000 per day, as the same is higher in decree. Now, my lord, this particular finding of reducing it to 500 that we have challenged for another civil revision CRP, where we have taken harping upon the law, my lord, already laid down established law of Supreme Court, that every decision of the court should be backed by reason. No reason was recorded. I will come to that later. Now, my lord, let me deal with my learned friend's submission. Now, this, my lord, legal position between the plaintiff and the, my lord, defendant, subsequently appellant and the respondent, and now, my lord, the petitioner and the respondent, my lord, cannot be diluted just because there was an acquisition notice, my lord. What my learned friend is submitting here, my lord, he is trying to say, project a picture that he will not be liable to pay any money on account of area rent, which is decreed by the court, and not and the compensation also, my lord. That will be a very preposterous submission, my lord. And if at all, my lord, if at all, if we presume that tomorrow the government becomes the owner of the property because of the land acquisition, the government becomes the owner. Even then, lordship is aware, in a proceeding under Urban Area Rent Control Act, it is not the owner who institutes the suit, it is the landlord. And landlord and owner are defined in different footing, my lord. Landlord is whoever collects rent, my lord. And there are many authorities of our honorable court which has distinguished this aspect of the matter. Even, my lord, if I am to read the definition of landlord, my lord, in Urban Area Rent Control Act, the status of the respondent has not changed because of the land acquisition notice, my lord.
Section?
My lord, section 2, 2C, my lord. The landlord means any person who is for the time being receiving or entitled to receive rent in respect of any house, whether on his own account or on behalf or for benefit of any other person, or as a trustee, guardian or receiver of any other person, and includes in respect of his subtenant, a tenant who has sublet any house, and includes every person not being a tenant who from time to time derives title under the landlord. So in my respectful submission, the suit was instituted in the capacity by the respondent as plaintiff as a landlord. That position has never been diluted. And therefore, my lord, well, I think in one case, my lord, Baliram Gupta, since it has just now come to my mind, my lord, Baliram Gupta versus Mohammad Isa, way back in 2009 or 10, I forgot the year, my lord, Honorable Justice Ansari has clearly laid down this law by following other precedents also, that landlord need not be the owner of the property. Landlord is the one who collects rent. Therefore, my lord, now who can institute the suit, my lord, under section 5? This is because under the Urban Area Rent Control Act, it is only section 5 which empowers the landlord to file a suit for eviction, ejectment, my lord. It is the landlord, my lord. It is the landlord who institutes the suit, my lord. So, my lord, by virtue of this circular which has been brought on record by before your lordship, my lord, the position of the respondent as landlord has not been altered, my lord. Therefore, the benefits which he have derived from the judgment and decree of the trial court, as well as the appellate court, shall remain with him. Those benefits cannot be snatched away because of this circular, my lord. My lord, in a slightly different context, my lord, Honorable Supreme Court, in a case with 2018 judgment, my lord, Konoklata Das and others versus Nobokumar Das and others, my lord. If your lordship directly comes to paragraph 11.1, my lord. 11.1, I'm reading some of the paragraph where because my learned friend here is, through his affidavit, he is asking the state of Assam to be made a party. Now he says the state of Assam might have become the owner. Let it be that as it may, even where there is a dispute in a rent control matter over ownership, my lord, where co-owners have challenged or are seeking to interfere into the proceedings, that the landlord does not have the right, my lord. The Supreme Court has clarified the law, my lord. May I just read out, my lord, from paragraph 11. There are some, has your lordship got paragraph 11? There are some well-settled principles of law on the question involved in this appeal, which need to be taken into consideration while deciding the question which arose in this appeal. These principles are mentioned in FRA 11.1. First, in an eviction suit filed by the plaintiff landlord, my lord, against the defendant tenant under the State Rent Act, the landlord and tenant are only necessary parties. In other words, in a tenancy suit, only two persons are necessary parties for decision of the suit, namely the landlord and the tenant. This position has remained. 11.2. Second, the landlord plaintiff in such suit is required to plead and prove only two things to enable him to claim a decree for eviction against his tenant from the tenanted suit premises. First, there exists a relationship of the landlord and tenant between the plaintiff and the defendant. And second, the grounds on which the plaintiff landlord has sought the defendant's tenant's eviction under the Rent Act exist. Hence, these two things are proved, the eviction suit succeeds. 11.3. The third question of title to the suit premises is not germane for the decision of the eviction suit. In an eviction suit, this is meaningless, my lord. The reason being, if the landlord fails to prove his title to the suit premises but proves the existence of relationship of the landlord and tenant in relation to the suit premises and further proves existence of a ground on which the eviction is sought under the Tenancy Act, the eviction suit succeeds, my lord. That is what was my humble submission, my lord. That I need not establish ownership here, my lord. It is sufficient if your lordship, after perusal of the records, comes to the knowledge, the factum, my lord. If it is established before your lordship that I am the landlord, it is sufficient to sustain the decree, my lord. Conversely, if the landlord proves his title to the suit premises but fails to prove existence of relationship of the landlord and tenant in relation to the suit premises, the eviction suit fails. 11.4. For the plaintiff being a dominus litis, my lord. It is in the domain of my domain, my lord. I was the plaintiff. Whom should I implead? Whom I should not? I am not seeking for an amendment of the plaint now. I am not saying that the state of Assam should be. Dominus litis is in my favor, my lord. I am in the domain of the facts, my lord. Cannot be compelled to make any third person a party to the suit, my lord. Be that the plaintiff or the defendant against his wish, unless such person is able to prove that he is a necessary party to the suit, and without his presence the suit cannot proceed nor can be decided effectively. In other words, no person can compel the plaintiff to allow such person to become the co-plaintiff or defendant in the suit, It is more so when such person is unable to show as to how he is a necessary or proper party to the suit, and how without his presence the suit can neither proceed nor it can be decided, and how the presence is necessary for effective decision of the suit. 11.5. Fifth, a necessary party is one without whom no order can be made effectively. A proper party is one in whose absence an effective order can be made, but whose presence is necessary for a complete and final decision on the question involved in the proceeding. Here, state of Assam involvement is not necessary. Sixth, if there are co-owners or co-landlords of the suit premises, then any co-owner or co-landlord can file a suit for eviction against the tenant. In other words, it is not necessary that all the owners of the landlord should join in filing the eviction suit against the tenant. Keeping in mind the aforesaid well-settled principle of law, and on examining the legality of the impugn order, we find that the impugn order is not legally sustainable, hence this is the principle of law, my lord. So in my respectful submission, the argument of my learned friend cannot be sustained, my lord. The Supreme Court authority which he has tried to rely upon through his affidavit, that if a proceeding is nipped in the bud, my lord, then the consequences orders will also be automatically waived, my lord. That principle relates to some other proceedings, my lord, not in this type of proceeding. Here a suit was instituted in the year 2010. 2020, a judgment is, my lord, in favor of the respondent. 2022, the judgment is reaffirmed by the appellate court, my lord. So that is my submission. Now, regarding, my lord, that the fact, another argument which he has developed, that if your lordship instructs, he will again pay the rent twice. He has paid the rent once before. Where is it in the judgment? My lordship will definitely not traverse beyond the facts recorded in the judgment, my lord. And if there was any NJ case which he is trying to now project, that burden lies upon him, not on the respondent, my lord. It was his burden, tenant's burden to discharge before the court, that even during the pendency of the suit, he was depositing rent. Regarding this, my lord, let me just another judgment of Honorable Justice B.P. Kotoki, my lord. Paragraph 13, my lord. I highlighted the portion, my lord. If your lordship peruses paragraph 13, my lord, under the provision of 1972 Act, the burden is on the tenant to pay the monthly rent to the landlord on the date when it fell due, and in the event of refusal to accept rent by the landlord when the same was offered, duty is cast on the tenant to deposit the same in the court with proper process fee, etc., within a fortnight of his falling due. The tenant can claim protection from eviction only in case the rent is paid or deposited in accordance with the provision of Section 5 of the 1972 Act. The burden is also on the tenant to prove that such rent was paid or deposited in the event there is any allegation that such rent not paid to the landlord in time. He cannot come here and say that that area rent I have already deposited, only 2 months have remained. Where is it in the judgment, my lord? Even in the appellate court being a continuation of the suit, my lord, when your lordship sits in a regular appeal, my lord, first appeal, it's a continuation of the suit, my lord. He could have filed a petition for adducing evidence. That scope was available to him. Now it will not lie in his mouth to say that, no, I had already deposited the land. This is not 1,25,000, only 2 months rent is remaining. Where is the iota of evidence? Hardly, my lord, I'll just trouble your lordship with one more judgment, my lord. Lordship is already aware, my lord. I'm just, since this was, my lord, again followed by another bench of our court, my lord. My lord, this is a constitution bench judgment, my lord. Hindustan Paper Corporation Limited versus Dilbahar Singh, my lord. paragraph 43, my lord. State here, take your lordship to page 101, my lord.
Yes.
We hold, as we must, that none of the above rent control acts entitles the High Court to interfere with the finding of fact recorded by the First Appellate Court / First Appellate Authority, because on reappreciation of the evidence, its view is different from the court authority below. The consideration or examination of evidence by the High Court in revisional jurisdiction under this act is confined to find out the finding of facts recorded by court authority below in according to law and does not suffer from any error of law. A finding of fact recorded by court authority below, if perverse or has been arrived at without consideration of material evidence, or such finding is based on no evidence or misreading of evidence, or is grossly erroneous, that if allowed to stand, it would result in gross miscarriage of justice, is open for correction because it is not treated as finding according to law. In that event, the High Court, in exercise of its revisional jurisdiction under the above rent control acts, shall be entitled to set aside the impugned order as being not legal or proper. The High Court is entitled to satisfy itself as to the correctness and legality and propriety of any decision or order impugned before it, as indicated above. However, so to satisfy itself to the irregularity, correctness, legality, or propriety of the impugned decision of the order, the High Court shall not exercise its power as an appellate power to reappreciate or reassess evidence for coming to a different finding on facts. So, Lordship, today he cannot come up with a new evidence and say that I have deposited the rent, when those evidences were never placed either before the trial court or the appellate court. And this judgment was, my lord, followed by our High Court. This judgment, my lord. Plus one paragraph, my lord, one paragraph. Page number 2, paragraph 3, my lord. For the purpose of deciding as to whether court should exercise its revisional jurisdiction against the impugned judgment and decree, this court finds it relevant to refer to the judgment of the Supreme Court wherein the scope of revisional jurisdiction was explained. First, that particular paragraph which I have just now read, my lord, was quoted, my lord. And this has formed the basis, my lord. The contours, my lord, the contours which will govern the revisional court. Therefore, my lord, in my respectful submission, this revision petition is devoid of any merit, my lord. And the fresh ground which is trying to take, my lord, is also not available, cannot be available to them, my lord. If the land is acquired by the government, it may go, we do not know what will happen. Government may change its mind then, my lord. And they are, since 1988, they have been our tenant, my lord, my client's tenant. So this is my submission in regarding the first case, my lord.
Regarding the other.
My lord, I have to submit more, my lord, because I have not completed my argument. My submission is still there.
Yes.
Now, your lordship may kindly come to page number 29, my lord. Page number 29, my lord.
Yes.
This is agreement of lease. First party is lesser, second party is lessee. Lease and tenancy agreement is different. Lease is governed by the Transfer of Property Act. Rent Control Act is applicable for the Tenancy Act. There cannot be any argument against the written documents, my lord. The documents clearly says prepared by the respondent, agreement of lease. Agreement of lease, no, there is no definition of landlord. Now, your lordship may kindly come to this page number 37, my lord, plaint. Prior to that, my lord, it starts from page 36, my lord. In the bottom, your lordship may kindly see. The relief of area rent is valued at rupees 1,25,592, as well as, yes, only for the month of April 2010 as well as July 2000. So this is the contention, this is the pleading that I am defaulter if supposing but not admitting, if the petitioner is defaulter is filed only for April 2010 and July 2010. Now, your lordship may kindly come to page 37. My lord, my learned brother has projected as a landlord. What is the pleading? That the plaintiff is the owner. It is his contention, his pleading. And in view of this, my lord, he is no more owner by operation of law. I am not saying he is not owner. Law is saying he is not owner. There cannot be any estoppel against this suit. And here this, my lord, here, my lord, the judgment is there. This relating to the Assam Land Acquisition Act, my lord. The Honorable Supreme Court says the recent decision of the Constitution Bench of this court has also affirmed that once possession is taken by the state, the land vests absolutely in the state and title of the landowner ceases. Everything is seized, not only his ownership, all rights and liabilities seized. So during that period, he was landlord or landowner, whatever may be there. But by operation of law, he is no more there. Now, his prayer before the learned court was for this bona fide requirement and defaulter. Bona fide requirement has gone by the operation of law. He has not argued also. Now, my learned brother is relying upon the judgment. Before judgment, we have to see what is the pleading. Any judgment which is going beyond the pleading is perverse and not valid in the eye of law. Page 40, my lord, of their plaint. Page 40, my lord. Paragraph 9A.
Yeah.
It is pertinent to mention herein that the plaintiff has been withdrawing the monthly house rent so deposited by the defendant through NJ before the court per month. Till today he is withdrawing. I am depositing. Has been withdrawing, depositing. This is the English, which is clearly saying has been, and this is a fact. Even today, we are depositing and they are withdrawing through the bank. On refusal, we have to pay through the court. We are paying in the court. Even we can produce the proof also. So this now they are saying the compensation. Compensation for what? There cannot be unjust enrichment. Learned court, we have challenged both the judgments because all the judgments are perverse. They have traveled beyond the pleading. They have traveled beyond this, my lord, prayer and relief. And in this respect, my lord, I am referring this one judgment of the Honorable Supreme Court. 2008, volume 17, SCC 491. This is very good judgment on the CPC. Lordship at paragraph 10.
This is the aspect of second. 100.
Yes, but we
are dealing with one civil revision petition, not second appeal.
yes, but even beyond the pleading, if something is recorded by the learned court below, then it is perverse. Even in revision also, this your lordship can interfere. Now, here it is clearly admitted We are paying and they are withdrawing through the NJ case. By argument, one cannot dispute. Now, your lordship may kindly come to the next page, your lordship. They are taking the rent also and they are claiming the compensation also. There cannot be unjust enrichment. Page 41.
And the enrichment does not arise because the decree is of 2020.
Yes.
Execution is of recent.
I am not on that, my lord. I am saying I am paying the rent and they are withdrawing the rent. And apart from that, they are claiming compensation. This is the purpose. And your lordship may kindly come to page 41.
No. Where is the document to show that they have been claiming compensation?
Yes, there is a pleading. On the basis of pleading, the learned court below has awarded 2,000 per day. Despite they are taking the rent also. This is the perverse finding. And
No. That will continue till the acquisition proceeding was acquisition notice was published.
my lord, we do not know the date, but till today we are paying the rent. Even till today. Continuously, there is no default. And I can satisfy your lordship by getting the accounts through which we are paying. And there,
When you will produce it?
your lordship, within 1 week we will produce. Yesterday we discussed everything. Every time they are paying.
On the other day, if knows that we are going to hear the matter today, you could have produced it today.
My lord, his mother was admitted in Calcutta, my lord. Seriously. So some operation was going on. So he came, he reached at 4 and he met me. So this is the difficulty. We can produce, your lordship, because justice is the main thing, my lord. Your lordship has to arrive the facts, finding of it and truth. What is the truth? For that, your lordship can exercise power. Even inherent power is there, your lordship can exercise there. Even writ power also.
That inherent power cannot be exercised in similarity.
When it is required, my lord, if there is an injustice, my lord. But the purpose of trial is to find out the truth. So the Honorable Supreme Court says no stone can be unturned to find out the truth.
Better to do one thing. Let's produce whatever.
Yes.
We'll keep the matter as part.
Yes.
Now, lordship, but my submission is that those were never exhibited before the trial court. My humble submission, only my.
Right. Those are not exhibited, but let's produce it.
Yes.
See,
Okay.
will they decide the admissibility of the
Yes. That is a different thing. Yes.
Okay.
It may be fixed after 15 hours, my lord.
No. Not after the
That-
passage of August.
Any date, my lord, so that we are having some other outside cases, my lord. My learner brother is also.
No, I am here.
He is all along here. He has finished his outside assignment.
Hardness are out of the current product. And also hard data. Learning. Hard is the method. 12 August.
Yes. Oh, sorry, my lord. On 11th, my lord, I have one case in Patna. So it may be on 9th. 8, my lord, 8.
My lord, I mean, some difficulty. Lot of matters. 7.
Yes, 7.
Okay. Within that book of
Much obliged.
Deeply obliged.
Sorry, my lord, to mention at this our lordship, 18 lordship, with regard to item number 18 lordship, it's a hearing matter. Both sides are there. Today, lordship, we may be accommodated, lordship. We may do it on some other table.
when it may be
After 3 weeks.
it's agreed with or
My lord, I want to make mention, my lord, with respect to the item number 25. My friend is there, my lord. I may be allowed to withdraw this revision petition. The suit is dismissed. First appeal is dismissed, my lord. So, my lord, the client is have an instruction to file second appeal against the judgment of the first appellate court. So, in that case, my lord, we may be at liberty to make appropriate application. For
Liberty is not necessary. As per the law, they will go. But the whatever my learned friend is submitted, as per the order that has been last occasion lordship and directed to produce the copy. So I have already furnished the copy, my lord, there. In view of this, my lord, their petition itself is not maintainable, my lord. This is liable to be dismissed. It is not.
My lord, we may be allowed to withdraw, my lord.
Then withdraw. Liberty will not come, my lord.
So when I am withdrawing, my lord, my friend is should not.
Yes, yes, but I am agree with you. But liberty question is not come, my lord. Liberty, as per law, will take the course, my lord. There is no. This is a civil suit, my lord. The liberty is not a matter of things, my lord. There is a limitation is there. Everything is there, my lord. How the limit they will come against the my lord? This is the liberty. Yes, my lord.
My lord.
When they file appropriate application.
That will be by as per their court course.
Bar in granting liberty.
The liberty, my lord, I am not on that, my lord. The thing is that whenever they are choosing the other forum, they can go, my lord. There is no other things to be given liberty, my lord. As it law is itself saying the things.
Okay. Further air sector learning for the sector subjects that he has the instruction to and he also tries for granting liberty. The approach forum by filing appropriate.
Smile.
However, liberty the appropriate forum by filing.
Smile.
But one thing, my lord, I want to clarify, my lord. The liberty that not work, my lord, regarding the my lord, condoning the delay and everything, my lord. So only the liberty that put that action, my lord.
Liberty
Yes, only, my lord. Yes. Boss of my lord.
Deep lovely.
We see
May it please, my lord.
Article 1 of 2025.
My lord had fixed this matter for clarification. My lord had fixed this matter for clarification.
Yeah.
Yes, my lord.
The question is, without admitting the appeal, we can set aside the appeal judgment and order. Also, the learned reference court.
My lords, my submission would be that because this is an ex parte order, for as far as I am concerned, if I am able to satisfy to my lords that this matter in the proceedings before the reference court, I was not a party and I was not heard. So therefore, it is ex parte to me. So my respectful submission will be that in that case, my lords can remand the matter back without admitting. Actually, my lords may admit the appeal and also pass the consequential order, which would, in my respectful submission, if I'm able to satisfy my lords on the merits of the case, would be a remand back to the reference court, my lord. In fact, my lords will kindly see the judgment of that PGCIL, which I had referred to, my lord. In that case also, my lord, in a similar case of PGCIL itself on similar facts, my lord, with the judgment of this court, which I had placed reliance on, my lord, Power Grid versus Shri Porvat simply.
Yes.
In that case also, my lord, on the short point, This
Is
was
the
also,
relevant paragraph?
my lords, the relevant paragraph starts from, my lords, of the relevant paragraph would be para 4, where the contention is noted. Para 4, my lord.
Paragraph number?
4, my lord. 4, para
4.
4.
Okay.
4, my lord. I'm sorry.
Yeah.
I'm in the court, my lord. I'm so sorry. The connection is a little poor, my lord. I'm so sorry.
Yes.
My lords will kindly see the contention is noted at para 4.
Yes.
That I was not a party, which is the same, my lords. Then my lords will directly come to the last page, my lord. Last page of the judgment, para 11 and 12.
Yes.
So in view of the law laid down, my lords, the judgment which I have placed reliance on the same set of judgments, the court did remand the matter back, my lords, without going into the, my lords will kindly see the eventual consequential last line. The appeal is therefore allowed and is disposed of, my lord. So in this case, as I understand, my lord, subject to correction, my lord, this appeal was not admitted and then it followed and then went to the remand. So the order was possibly passed at the very threshold.
Okay. So this was a judgment of division bench.
This is a judgment of the division bench, my lord.
Okay.
Kindly see of this court, my lord, when it was the common court for all the 7 states, my lord.
Yes. Okay. Yes, Mr. Hazoika.
Yes, my lord, I am here. May it please your lordship. The appeal they have preferred, they are the Power Grid Corporation of India Limited. So, by application of Order 1 Rule 10, CPC, the Power Grid Corporation of India, they have been implicated as party in the proceeding. The Order 1 Rule 10 provides that in any stage of the proceeding, court has given that power to implicate necessary party. Accordingly, my lord, in the reference proceeding, the reference court has pleased to implicate Power Grid Corporation of India into the proceeding, my lord, in LA proceeding of Bisnath Chaili, Miss Case 1 of 2019. And the decision they have placed before your lordship, Navy Linked Corporation India Limited, that decision is not applicable in the present case, my lord. Here it is a case decided because the person interested, the corporation has not been made party. But in our case, my lord, that is not happened. In our case, my lord, Power Grid Corporation has been made party. And one of the learned counsel, he appeared before the reference court, and he also appeared for deputy commissioner. And that learned counsel, at the first instance, filed a petition before the reference court. He took the plea that the Power Grid Corporation is a necessary party in the proceeding. So, by application of Order 1 Rule 10, in any of the proceeding, that is the law, the reference court has implicated Power Grid Corporation of India. And Mr. Pranjal Upadhyay is the counsel. He appeared on behalf of Deputy Commissioner as well as Power Grid Corporation of India. And that is the view he projected before the reference court, that he is appearing for Power Grid Corporation of India as well as Deputy Commissioner. Now, my lord, question is, these petitioners, reference petitioner, they have been highly dissatisfied and aggrieved because of the decision of the Power Grid Corporation of India. They filed a petition before the Deputy Commissioner. In their petition, they have stated vividly that this reference petitioner, they are not entitled to higher compensation. Only 60,000 against 8 bighas of land each are entitled for compensation. That is the petition they have filed before the Deputy Commissioner, that is collector, in the LA proceedings. And the Deputy Commissioner, on receipt of such application from the Power Grid Corporation of India, tacitly accepted the determination made by the Power Grid Corporation of India. Then and there immediate, no notice has been served to the reference petitioner from the corporation, from the Power Grid Corporation of India or by the Deputy Commissioner. But Section 11 says compensation can only be determined by the collector. Here in the case, my lord, Power Grid Corporation has determined
Yes, Hazurika, perhaps the connection is interrupted.
But I also cannot hear him, my lord.
they approached before the High Court by filing a writ petition because they have been at their back compensation determined. And that compensation determined on the basis of Power Grid Corporation Limited, they have obtained an NOC from the reference petitioner, NOC in the form of affidavit. And accordingly, on the basis of that NOC that was a conditional NOC in the year 2006, that NOC was executed. And on the basis of that NOC, they have took the position of the reference petitioner. In their said letter, they have clearly stated that the reference petitioners, they are the small tea growers. The word tea growers, that is the word used by the Power Grid Corporation of India, and they are the unemployed
unemployed. We are not on the merit of the petition now, merit of the appeal now.
Now I am going there, my lord.
Whether the Power
at
Grid
the first
Corporation
instance,
was a party in the reference proceeding, and
yes,
whether
that is why, my lord,
opportunity
if
was
your
afforded
lordship,
to them
yes, if your lordship
at the
will
time of
peruse,
hearing.
if your lordship, I am coming to that, my lord. In the first page of the judgment and award delivered by the learned reference court, my lord, it is reflected that Dulab Dangi and 26 others versus Power Grid Corporation of India. And respondent, the petitioner advocate name has been mentioned there, as well as the name of the respondent also mentioned that he is Pranjal Upadhyay, who is representing Power Grid Corporation of India. So first page of the judgment speaks that Power Grid Corporation has been impleaded in the proceedings. They have been given sufficient opportunity to avail the benefit of Section 50 of the Land Acquisition Act 1994. That benefit they have not taken during the course of the proceeding. We have adduced our evidence because we are waiting several dates that they will adduce their evidence. Neither the Deputy Commissioner nor the Power Grid Corporation adduce any rebuttal evidence. Even they are not interested to cross-examine the witnesses of the reference petitioner. Now they are relying upon the decision of the Navy, that decision, Himalayan tiles, they are referring before your lordship. That decision is not applicable in our case, my lord. They've been given opportunity. When they have been given opportunity, they will not avail the benefit of the Section 50 of the Land Acquisition Act. The appeal in this situation, my lord, not maintainable. So LCR may be called for. Your lordship may peruse the LCR. and they've been directed to deposit 50% of the decretal amount, my lord, because it is a money decree. When order 1 rule 10 is applicable of the CPC, so order 41 rule 5 or order 21 rule 26 or CPC is also applicable at the same time. I have filed objections before that my objection not entertained by the reference court. When they are saying that provision of the CPC applicable, when provision of the CPC is applicable, they have challenged the money decree. When they have challenged the money decree, they have to deposit 50% of the decretal amount, and LCR may be called for. That is my submission before your lordship. Truth will come out.
Mr. Hazarika, please tell me, except this post-title of the judgment of the reference court, is there anything to show that the Power Grid Corporation was represented by Mr. Pranjal Upadhyay? Because there is a categorical statement made by the counsel for the appellant that Pranjal Upadhyay was never engaged by them.
Any document submitted before your lordship, panel advocate documents, my lord. They always prepare the panel advocate list, they prepare always, my lord. When they prepare panel advocate list in every district, my lord, in subordinate court, my lord, such a panel list placed before your lordship for perusal, for taking a concrete decision by your lordship. Even in the High Court, my lord, there is a panel. And panel is representing in power grid cases, my lord. So list they have placed before your lordship. Some advocate appear court and some advocate appear before the court.
Whether Mr. Pranjal Upadhyay is the panel advocate for PGC?
My lord, the way it works for any...
He has given to the court.
Let my learned friend finish, my lord.
That is the impression he has given to the court. That impression also given to me, my lord. When I have appeared and argued in the case, my lord, he stated that he is representing Power Grid Corporation of India as well as Deputy Commissioner, my lord. That impression he has given to me and to the...
My lord, I am sorry, Mr. Pranjal Upadhyay is not present in this court. I am sorry, my lords. Such statements cannot be made against a counsel, my lord. We have taken instructions. We have in fact contacted Mr. Pranjal Upadhyay whether such a statement was made before the reference court, and he has, my lord, categorically denied it. He has categorically denied that he has appeared for Power Grid at any point of time in these proceedings. He said, I have only appeared for the Deputy Commissioner. We have already checked with him, my lords, because time and again, my lords, my learned friend and my learned friend's colleague in the court has been raking up the name without, my lords, either my lords will call him to court or ask him to file an affidavit. My lords, dragging a lawyer's name to court and saying that he gave the impression is not correct, my lords. He has not been engaged by us. My case is, he was never our counsel, he was not engaged. He may have appeared in other cases, I am not aware. But in this case, no wakalatnama was given to him. I have taken categorical instructions. No wakalatnama was ever given to him. He was never authorized by anybody from Power Grid to appear in this matter. That's the categorical submission at my end, my lord. And if my lords...
Mr. Pranjal Upadhyay also...
My lords, I did not interrupt my learned friend. I did not interrupt my learned friend. So...
In wakalatnama for Deputy Commissioner. And even in the High Court, there is no provision for filing wakalatnama by the respondent state authorities, my lord, or standing counsel.
But my lords, I am not state. I am a corporation, my lords. I am a separate entity. I am not the government. So
The
for
government
every
of
case, my lords, I cannot argue this matter if my learned friend is going to go around and cross talk, my lords. Either I can submit or my learned friend submits.
Okay, Mr. Hazarika, let Mr. Sharma complete.
I did not interrupt my learned friend, my lord.
Yes, Mr.
My
Sharma.
lord, my submission is that I am not the government. I am, my lords, a corporation, which is a public sector undertaking, but a corporation nevertheless. So in every case, which is, my lords, contested by Power Grid in any court in the country, a wakalatnama has to be signed by the authority, the authorized representative, and submitted in court. And a specific authorization also is required, my lords are aware, authorization will also be required separately to authorize Mr. Pranjal Upadhyay in any case for that matter. In my submission, my lords, my clarification, I've already obtained that clarification. In fact, as I told my lords, Mr. Pranjal Upadhyay was actually contacted because of the submissions which have been made in the court repeatedly in the open court, because Mr. Pranjal Upadhyay's name was being dragged in. We contacted Mr. Upadhyay, my lord. He told that he's in Siliguri or somewhere. My learned friend, my instructing counsel had called him, Mr. Nitin Khera had called him, spoken to him. He has categorically denied that he has appeared for power grid at any point of time. And he has categorically said what is borne out of the record also, that he has appeared only for the deputy commissioner, my lord. And my lords will kindly see that is one aspect of the matter. The more important aspect is from the record. My lord will only see the record. What my learned friend is saying is completely off the record. There is an impleadment application which is filed on behalf of the deputy commissioner, which is, my lords, nomenclatured as 265. That application, as I have shown to my lords, every order, date by date, that application not been decided, no notice issued. That is not decided, my lords. Eventually, the main appeal is decided. That application never got decided, my lord. So if my lords were to go by the record, what my learned friend is now arguing is completely off the record. That is casting somebody's name, dragging somebody's name, saying that he represented to the court, he represented to the court, he represented to the court. But my lords, that is not borne from the records. Because eventually, if my lord sees, my lords will go. I'll just take half a minute, my lord. My only submission is my lords will look into the record, satisfy my lords. If my lords want me, I will go show the records again, my lords. The records clearly show that no impleadment application was decided to bring in.
Mr. Sharma, you have already shown me the orders and also the application.
Lordship. And that is all I'm doing. My lords, I am not saying anything off the record. I have shown the records of the. So I'm only on the record, my lords. What my learned friend and my learned friend's colleague in the court have been arguing till now is completely off the record, my lord. Completely off record.
Okay. Yes, Mr. Hazarika.
Navy case, my lord, they have placed before your lordship as the citation, my lord. And Navy case, my lord, decided because corporation has not been made party in their proceeding. So Supreme Court, Honorable Supreme Court says that a corporation is a necessary party. This is required to be implemented. But here our case is different, my lord. In our case, my lord, judgment speaks that Power Grid Corporation has been made party in the proceeding. And they've been heard. They failed to obtain the benefit of Section 50 of the Land Acquisition Act. As they fail now, they have understood the consequence of not taking of the benefit of Section 50. They approach and filed. State not prefer any appeal, my lord. It is an appeal preferred by the because the state not agreed. And they filed and sought for reference decision of the reference court is required to be set aside. That is where they have made in their memo of appeal. My question is not that it is not covered by the Nell Valley case, my.
No, that's all right. But Mr. Hazarika, you see the petition number 265 filed by the additional deputy commissioner before the reference court remain undisposed.
In that application, I have filed objection, not to
You have
implead.
filed objection, that's all right,
Objection.
but no order was passed.
My application not entertained because Order 1, Rule 10 speaks that court, any stage of the proceeding have a right to implead necessary party. That by application of the provision of the CPC, Power Grid Corporation has been made party. And judgment speaks of that by. That is my case, my. Now they are placing this judgment before your lordship and they have relied upon the decision of Nelveli. That is not applicable in our case, my. If I have not been implemented, if deputy commissioner has not been heard, then definitely state will come and file appeal. State not file appeal, my.
No, state
not agree.
State has not filed the appeal, that's all right, but This Power Grid Corporation is the person interested as defined in section 3 of the
My lord,
Land Acquisition Act.
some educated youth, they have been given 8 bighas of land for special cultivation, that is tea plantation, my lord. And they have developed the land in the tea cultivation. Therefore, they have been that they are the small tea growers. And their possession has been taken by the Power Grid Corporation on the basis of NOC given by the reference petitioner. Now they are saying that they are not, after obtaining NOC, they took the stand that this reference petitioner, they are not entitled higher compensation, they are only entitled 60,000 for 8 bighas. They have been given only 60,000 for 8 bighas. 60,000 for 8 bighas, my lord, as a shifting grant. Is it a compensation, my lord? Whereas
But,
land value is
they are-
more
they
than
are not the
50,000 per
landowners.
bigha.
They are not the
No, my lord.
landowner. The
LOT,
land
my
belongs
lord.
to the government.
LOT, there is a decision of the Honorable High Court also. LOT is their personal interest. Therefore, High Court has passed an order into the writ petition to file a reference application before the Deputy Commissioner. And on the basis of that decision of the Honorable High Court, my lord, in the writ petition, that writ petition order passed by the learned single judge, my lord, that has not never been challenged till date, my lord. We have filed reference petitioner, reference application before the Deputy Commissioner. Deputy Commissioner, after considering all materials, my lord, including record, refer the matter to the civil court for appropriate decision for determination of appropriate compensation.
Okay, okay.
From section, my lord, section 18, my lord, 18 to 28. These sections are related to payment of compensation by the reference court. From section 18 to 28, nowhere it is said that they are to be a patta holder, they are to be owner of the land. The word owner, pattadar, that word not mentioned from section 18 to section 28 of the Land Acquisition Act.
Okay.
My lords, one last submission, because my learned friend is now arguing on the merits of the case. My lords, the scope of the appeal is very, very narrow. Today, we are only on the point whether I was heard or not, whether I was made a party or not. And if my lords were to find that I was not made a party, then the only recourse is to remand the matter back. And the merits of the case, the merits of the case which my learned friend is arguing for enhancement of compensation, that, my lords, is obviously that recourse is open to my learned friend to argue, my lord, in the reference court.
Okay. Okay. We are uploading the. We are going to upload the order by 4 o'clock.
I am deeply obliged, my lords. I am deeply obliged.
May I please, Your Lordship?
Yes.
Your Lordship, IA 120725 has been filed by the respondent, my lord.
Number?
120725.
Yes.
Well, this IA has been filed. Your Lordship, I can take a judicial note that this second appeal was filed before this Honorable Court, Your Honor, here, my lord, which was admitted by framing, admitted by the order dated 28/10/24, my lord, by formulating two substantial questions of law. Your Lordship, I can see, I have mentioned in page 5 of my this application.
No, this RSA was admitted.
Admitted, my lord.
Yes.
Thereafter, my lord, stay was obtained. Long after, my lord, 28/10/24, stay was obtained, my lord, on 13/11/24, my lord. In between, my lord, degree was put in execution. After execution, satisfaction of the degree, my lord, stay was obtained,
And by virtue of this stay order, degree holder has not been allowed to get the benefit, fruits of the decree, my lord.
It has been executed.
Executed, my lord. This is on record, my lord. Judicial order, my lord. Your lordship.
No, the record has come, my lord. This record is going to the order has passed. That presiding officer was absent, my lord, on that date. Ultimately, that actual possession has not taken place. Actual possession not been handed over, and in the meantime, on the same date.
Let me submit. Let me submit. You'll get your turn. Let me submit, please. Respectfully. Lordship, your lordship, I cannot see whether presence of executing court is mandatory, my lord. That is not mandatory, my lord. Writ of delivery of position was issued to the bailiff by the executing court, my lord. And my lord, bailiff had executed the decree and submitted the report before the executing court. On the day of submission of the report, my lord, client of the executing court was on leave. Can it be said that the decree was not executed, my lord?
No, that report is available on the
Report is available, my lord, on record, my lord. I have annexed the copy of report. Your lordship, I cannot see. Report of the bailiff.
It is IA.
IA. It is IA, my lord.
Page number?
Just 1 minute. Annexure D, my lord, page 34. This is the warrant of delivery of possession, my lord, issued to the bailiff. Thereafter, your lordship can have to see annexure E, page 36. This is the report of the bailiff. This is translated version, my lord. Original vernacular is at page 37, my lord. Page 37.
Yes.
Report is of, my lord, 26/9/24.
26/9/24.
What report says your lordship may kind of to consider? I am reading, my lord, from page 36 in HRE. May I read your lordship?
No, another order of the executive court is there at page number 30.
Page number 32, my lord.
Yes.
This
Order
is
dated 13/11/24.
24, my lord. This is on this date, my lord. The report of bailiff was accepted by the executive. Accepted by the executive.
Yes.
So, my lord, on record, judicially, my lord, degree was executed, my lord. Position of the degree land was delivered to the degree holder, my lord. Now, you know, my lord, by virtue of stay order, degree holder has not been allowed to get the benefit of the degree, my lord. He has not been allowed to enter into the land, my lord. Possibly and illegally. That's why, my lord, I am agreed by this.
No, while the application for stay was filed,
My lord.
the council has assured this court that
May I submit respectfully, my lord? There was some, my lord, misleading, my lord, submissions, my lord. With all respect and regard, my lord. Lordship, I can take judicial note. I have annexed the order sheet, my lord. This starts from page 25. Page 25, my lord. Case 25. Well, this is the order of the executive court, 12/6/24. Case record put up before me, seen and pay the case record. It appears that the original suit pertains to the Court of the Civil Justice Unit Division number 2, Bopeta. Accordingly, instant execution cases you don't from the Court of Civil Justice Unit Division number 1, Bopeta, to my file and transfer to the Court of Civil Justice Unit Division number 2 at Bopeta for disposal. This is the first order, my lord. Thereafter, your lordship can see original case record was tagged, my lord. Then page 28, my lord. Order dated 28/9/24. Degree holder is represented. Learned advocate for the degree holder has taken steps of writ of delivery of possession to the bailiff of the court and concerned Lord Model issue the writ. This was the order, my lord. This was placed on record before at the time of obtaining stay. Thereafter, my lord, degree was executed. And my lord, after that, my lord, stay was obtained.
Your Lordship can see page 20. Order dated 13/11/24, my Lord. All along, my Lord, appellant was having knowledge and information regarding the orders passed by the executing court. All along, my Lord. Why, my Lord, I am citing this order says, Your Lordship may kind of to see page 20. Hard Mr. N.K. Kalita, Landed Counsel for the applicant. Here is the order dated 8/11/24. Mr. Kalita, Landed Counsel for the appellant has produced the one copy of order dated 29/24 passed by the Civil Judge Unit Judgment number 2 at Guwahati in Tatel Execution Case number 33/24 and submits that the learned executing court has already issued warrant by order dated 29/24. My Lord, issuance of writ of delivery of position was well within the knowledge and information of the appellant, my Lord. This was executed on 26/9/24, my Lord. This was also within knowledge. That has been suppressed, my Lord. By suppressing the same, my Lord, this stay was obtained on 13/11/24. Respectfully, my Lord, I am submitting. My Lord, already issued warrant by the order dated so and the matter was fixed on 1/10/24 for report, and thereafter the matter has again been fixed on 13/10/24, my Lord. In between, my Lord, writ was executed. Report was submitted before the executive court. This was within the knowledge and information of the appellant, my Lord, but that has been suppressed. That has been suppressed.
No. The concept for the other day,
my Lord,
has pointed out that he was never informed that the degree was executed. Therefore,
there must be miscommunication between the appellant and his counsel, my Lord. So I'm not submitting on that, my Lord. But my Lord, this order says, my Lord, this was obtained, my Lord, after execution of the decree, my Lord. This has been creating hurdle to the degree holder, my Lord. So this requires certain modifications so that, my Lord, degree holder can get the benefit of the fruits of the degree until and unless, my Lord, degree is reversed by this honorable court in the second appeal. Furthermore, my Lord, may I submit one thing respectfully before your Lordship. Lordship, substantial question of law formulated at the time of admission of appeal is this, my Lord. Your Lordship may conduct to see. I mentioned the same in my application. Page 5, my Lord. May I read it?
Page
5 of this IA. Page 5 at the bottom, my Lord. May I read?
No. It's a substantial question of law.
I have quoted, my Lord, in my application.
Yeah.
Page 5, my Lord. Whether the learned first appellate court as well as the learned trial court have erred in law in traveling beyond the pleadings as well as evidence on record, while respondent herein have prayed for a degree in respect of Dag number 17, KP Pata number 141 of village Moriapur under Moja Paka in Bapeta district, whereas the degree has been passed by the learned court in respect of Dag number 17, KP Pata number 155 of village Moripur under Moja Bilterla, under Moja Paka in Bapeta district. Lordship, for this purpose, I have filed a certified copy of plaint, my Lord, original plaint.
No, we are not on the merit of the second. We are only on modification.
My Lord.
Yeah.
Because, my Lord, this allegation is also, my Lord.
Question of law, definitely we will hear you.
My Lord. Already record has come up, my Lord. This will show that no degree has been passed beyond the, my Lord, pleadings, my Lord. Because, my Lord, along with the memo of appeal, one copy of a plaint was filed, which was not correct, my Lord. This was subsequently amended, my Lord, by inserting the Dag number, KP Pata number 155. That plaint has not been placed on record, my Lord, along with saying it appeal.
Okay, at the time of
My Lord.
yeah.
My Lord, that the plaint is, my Lord, a recovery of cash possession, my Lord, because they are plaintiff, my Lord, and my Lord, that the appeal is dismissed. If even, my Lord, that execution is completed, nothing remains, my Lord. Even if I own the appeal, my Lord, how I file the execution? Because execution, if it is executed and demolish everything, my Lord, and they entered into that, my Lord, matter is end. That's why that's why my humble prayer, my Lord, considering the urgency, entire matter may heard at early. Because the main crux of case is that counterclaim filed by the respondent, defendant, that they have passed.
Oh, definitely we will hear you upon the.
Because infraction was appeal infraction, appeal admitted prior to 1 month prior to that. And he's
Yes, sir, but it appears that this order was obtained by suppressing the material fact.
My lord, that on the even on the passing of the date, my lord, actual possession is, my lord, is in the defendant today, still today, my lord, is in the hands of defendant. My humble submission, my lord,
No,
if
sir,
the case is
no.
Your lordship, they cannot consider, my lord.
My lord, one thing may consider, my lord, that main crux of the case is, my lord, that I have an unregistered sale deed. That sale
That is
deed, my lord,
that is merit of the appeal, my
70,
lord.
my lord.
That is merit of the
Because,
appeal.
my lord, merit of the case, my lord. My lord.
We are not on the merit
Eight
of
of
the
yes, my
appeal
lord.
now. We are on the application for modification of the
Yes, my lord.
hearing order.
My humble submission, if it is, my lord, allowed, my lord, the appeal is amount to infectious. Because, my lord,
But this was obtained by suppressing the material fact.
It is
my lord, that is not, my lord, I can say, my lord, on that date, it's a even today, my lord, that the execution has not yet complete. Until and unless execution is complete, my lord, honorable court may stay.
No, the report speaks otherwise.
May I submit your lordship? One thing only, my lord. My lord, against this affidavit has been filed by the appellant, my lord. In this affidavit, my lord, appellant claims that he is in possession. My lord, how he can be?
Yes, my lord,
Because, my lord, judicial order is there, my lord. Report of the belief is there, my lord. That was accepted by the London executing court on the same day when the stay was passed, my lord. That has not been challenged, my lord. Then how he can be in possession, my lord? He cannot be in possession, my lord, judicially. Judicially, I have been put in possession, my lord. Number one. Secondly, my lord, he says that if the stay is vacated, modified, then appeal will become incorrect. This is incorrect submission, my lord. Okay. Suppose, my lord, if this appeal is allowed, they shall have the remedy under section 114 of CPC, my lord, for restoration of possession. That is already open. When degree is reversed, then that can be put again in possession, my lord, under section 144 CPC.
They are waiting years together. Let them 1 month or 2 weeks, my lord. Let
No,
them
why, my lord? Why?
Because, my lord.
Why?
Then
What for, my lord?
another litigation will arise, my lord.
Okay, we'll pass the order.
My lord.
Because, my lord,
my lord, I have been
that in my case, although your lordship is not inclined to go to merit, my lord, then the exhibit A, which is the unregistered sale deed, it's prior to my, it's 1970. It's more than 30 years. That substantial question of lordship has framed. And according to Transfer of Property Act, my lord, A, immovable property, transfer of property section 54, my lord, sale, then if a property less than 100, well, registration is not required. It's a Supreme Court judgment is also there, my lord, in that regard. So if their case is they have purchased, if they have purchased, my lord, and possessing the land, the question of, my lord, ultimately they will not get the stay in the execution, my lord, the vacation of execution. And one more thing is, my lord, that they have in their PW evidence, my lord, they specifically stated that last 15 years I am in the possession. Suit of 2015, that they have got mutation 2013. My lord, without, my lord, possession, a land cannot be mutated under section 51.
My lord,
and
those are
52
not the question to be decided now, my lord.
Not
My lord, regarding
that's why my humble submission
regarding
case,
exhibit A,
entire case may be heard.
regarding exhibit A, my lord,
At early-
question of admissibility is there, my lord, because they have not filed it along with WS or counterclaim when they filed, my lord, at the time of evidence.